Good morning, everybody. Happy Wednesday. Welcome to TCF Live. My name is Dan Soul. I will guide you on a 3-hour journey through Courtlandia, starting in Allegan County with Judge Skocelas.
Prosecutor's office on a charge of domestic violence. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Clifman for the limited purpose of arraignment. We have reviewed the charging document and waived its formal reading, and Mr. Clifman will be pleading guilty today, Your Honor. Thank you.
And I understand why the prosecutor's office failed to notice this as a felony level domestic violence. Okay. Mr. Clifman, the charge you're pleading guilty to is a charge of domestic violence first offense. This charge is a misdemeanor charge. It carries a maximum penalty of 93 days in jail and a $500 fine. Knowing that, do you still wish to plead guilty to the charge of domestic violence?
Yes.
On July 6th of this year, you signed this advice of rights sheet. Before you did you read and understand all those rights?
Yes.
Those are your trial rights. If you plead guilty, you will not have a trial and you will give up those trial rights. Do you understand that?
Yes.
Has anyone promised you anything regarding what your sentence will be if you do plead guilty today?
No.
I have not agreed on what your sentence will be. Knowing that, do you still wish to plead guilty?
Yes.
Even for the first offense, you could receive on this case up to 93 days in jail. Knowing that, do you still wish to plead guilty?
Yes.
Anyone threaten you to force you to plead guilty?
No.
Is it your choice to do this?
Yes.
And finally, are you pleading guilty to this charge because you believe you're guilty of this charge?
Yes.
Is Emma Renee Hunt a resident or former resident of your household?
Former.
Former, okay. On June 25th of this year, here in the city and county of Allegan, did you assault Emma?
Not directly, but yes.
Okay. It's impossible legally to indirectly assault someone. Did you assault Emma? Yes or no?
There's no physical contact. No.
No. How did you assault Emma then?
We are throwing objects at each other in an argument, and then
Okay. So what did you throw at Emma?
she threw a bottle at me, and I picked it up and threw it back at her.
Okay. So you threw a bottle at her with the intent to hit her?
No, I was really intent to hit her. Just mad and threw it back at her direction because she threw it at me.
Okay. So again, did you intend to assault Emma?
No.
Okay. Based on that, I will not find a factual basis. You want to talk to the public defender further on this?
Sure.
Okay. He will talk to you at the end. So at this point, Mr. Badger, do you want to have a not guilty plea entered or talk to him further first?
I would prefer to talk to him further, Your Honor. Thank you.
We're going to put this case on hold. Mr. Clifman, the public defender, will talk to you further, and we'll pick this case back up after he's had a chance to talk to you again. Have two cases on Emmanuel Gerald Milligan. These are files 261971SM and 261970SD. Both of these cases are based on the same citation that was issued by the Allegan County Sheriff's Department on charges of operating an uninsured motor vehicle. Charges of operating a vehicle with an improper plate, a permit violation for a driver's license, and operating all of that while intoxicated. So I have 4 separate files here. Operating an uninsured motor vehicle, improper use of a registration plate, a permit violation, and operating while intoxicated. Mr. Badger, please, on all 4 of these cases.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Milligan for the limited purpose of arraignment. We have reviewed the charging document and waived its formal reading. Mr. Milligan will be entering pleas of not guilty and does qualify for a court-appointed attorney. We request this matter be set for a pre-trial and a jury trial, Your Honor. Thank you.
First, on the charge of operating while intoxicated, one or not guilty plea, set this for a jury trial, indicate you're requesting an attorney at public expense. Court file shows you released from the Allegan County Jail on a $500 personal recognizance bond. Bail will be continued in that amount with the condition you not possess or consume any alcohol, marijuana, or illegal controlled substances while your case is pending. Case will be set first for a pretrial conference with the prosecutor's office, and then for a jury trial in this courtroom, District Courtroom A. Public Defender's Office has determined you are indigent. They will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at the date and time of your pretrial conference. On the charge of operating an uninsured motor vehicle, will also enter a not guilty plea. Set this for a jury trial. Again, indicate you're requesting an attorney at public expense. In this case, bail was set at warrant authorization at $500 personal recognizance. Condition of bail on this charge is that you not operate or allow to be operated this 2013 Ford that you drove in this case until valid Michigan insurance is obtained on that vehicle. This case will also be set for a pretrial conference with the prosecutor's office, and then for a jury trial in this courtroom, District Courtroom A. Again, the Public Defender's Office has determined you are indigent. They will be appointing an attorney for you at public expense, and the attorney will discuss your case with you at the date and time of your pretrial conference. On the charge of improper use of a registration, will also enter a not guilty plea. Set this for a jury trial. Again, indicate you're requesting an attorney at public expense. Bail in this case was set at $300 personal recognizance. Bail will be continued in that amount at this time. Again, the Public Defender's Office has determined you are indigent. They will be appointing an attorney for you on that case as well. So an attorney from the Public Defender's Office will discuss your case with you at your pretrial conference. On the fourth file of a violation of a temporary learner's permit, will also enter a not guilty plea. Set this for a jury trial. Again, indicate you're requesting an attorney at public expense. Does not appear bail was set on this case. Will set bail at $200 personal recognizance with the same conditions as the other three criminal cases. This case will also be set for a pretrial conference with the prosecutor's office, and then for a jury trial in this courtroom, District Courtroom A. Again, the Public Defender's Office has determined you are indigent. They will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at your pretrial conference. So, sir, all four of your criminal cases are going to be set for pretrial conferences. Dates and times will be sent to you in the mail by the clerk's office. You are free to hang out from the court proceeding this morning. Be looking for your court appearances in the mail. Okay? File 2614.
Good morning once again, everybody. It is TCF Live on a glorious Wednesday. Yeah, it's Wednesday. Glorious Wednesday morning. Good to have you all with me. So the case before this one where the plea kind of fell apart there, somebody in the chat had mentioned like a mutual combat situation. So I thought I knew this and I looked it up just to be sure. Michigan does not recognize mutual combat. To the point where two people cannot say, hey, let's fight each other, so they mutually agree that let's go fight, and that's okay. It does not exist in Michigan. Either party can be charged with assault, and in this case, since they were charging the male, I would assume that the evidence pointed closer to him starting everything. Michigan does have a stand your ground, so if somebody comes at you and starts to fight, then you have a right to defend yourself. But actual mutual combat there does not exist. So just thought I'd bring you up to speed on that. Okie dokie, let's turn it up a notch. Lake County, Judge O'Donnell.
We're here on 23-154, 23-602, Dante Glenn. Here for a final hearing on the first violation, which was positive screen for marijuana June 4 and June 10. You understand that charge?
Yes, sir.
And then admission of marijuana and alcohol use on June 4, you understand that charge?
Yes, sir.
And we're here on the addendum. Failure to report is scheduled June 11 and June 18. Do you understand that charge?
Yes, sir.
Also, a positive test for marijuana, amphetamine, methamphetamine on June 22. You understand that charge?
Yes, sir.
And that is for a probable cause hearing. Mr. LeConte, what's he want to do?
Your Honor, with regards to the supplemental, we'll waive probable cause.
All right, is he going to plead guilty on all these charges?
Yes.
All right, is that what you want to do?
Yes.
All right, what's your plea to all these violations?
Guilty.
I'll accept your guilty plea and find you guilty. Mr. LeConte, go ahead.
Your Honor, I've had a lot of discussions since the last time we were here with Dante and also with several of his family members, including his mother and his girlfriend. As the court, I think, is aware, his mother actually came here this morning. She was going to speak on his behalf, but she's watching a granddaughter. There was a decision made since we were in chambers for her to take the granddaughter out. They didn't want her to watch the proceedings. Dante has had a lot of things occur in his life over the past number of years. He's got 3 different family members that died. One of them, at least one of them, violently. He has not dealt with those losses well. The mother expressed that to me. The girlfriend has. There were recent cemetery visits just prior to these violations that they know that he made, some of them along with other family members, to this cemetery. He has not dealt with that grief in their eyes very well, and they believe that that's behind a lot of these issues. I've talked to Dante extensively about his attempts on probation, on regular probation, to overcome some of the drug usage and what may now clearly be a need for some psychological counseling. I think, and I believe his mother and girlfriend both feel, that he needs some professional help. So I'm going to request that the court consider like an Oak House or NeoCap program for him. I believe both of them can do the dual program with him to help him deal with the grief issues that may be behind a lot of the drug usage.
All right, thank you. Ms. Crook, do you know how many days he is in on 154?
Yes, I do, Your Honor. The total number of days on 154 is 137 total days, and on 602 it's a total of 95 days.
And 31 on these violations?
31 on the violations.
All right, Mr. Glenn, what do you want to tell me?
Your Honor, I just want to say, I appreciate the opportunity that you've given me, and I know from the outside looking in, it looks like I need substance abuse help. And I mean, you can say I do, but to me, I really think I need help with grief counseling.
The statement you just made recently, like how recently?
I lost my daughter in 2022, February 14th.
Okay.
So I don't wake up every day and just say, F probation, I'm about to get high. I don't smoke recreationally. I don't. It'd be circumstantial, Your Honor. It'd be circumstantial where I think something happened, and it's just like,
so
I don't even think about probation
if you have these mental health problems.
That's what I need help with.
Well, that's fine, okay. And if you're compounding that with this drug stuff goes back. Okay, so this stuff goes back 30 years. Without the grief.
And I was using it recreationally.
Well, I don't know what recreationally means.
Since I've been on probation, you can see, I don't go every day. I'm not testing positive every week, every day.
Yeah,
I'm testing positive
yeah,
one time out of a 4 or 5 months. Like you told me, I'll get in my by getting the help that I need. Like I
Understand where you're at?
haven't caught no more cases. I've been case free. I haven't caught no more cases.
You're here for 2 cases, okay? You can't erase the past, okay? Because in your case, the past is pretty strongly predicted your future, and then sometimes you just don't show up. You don't show up here. You don't show up there.
Every time I sent Jamie when I was supposed to go to work, I busted a tire, and then when he told me that, my lawyer called me and told me, said, you got a warrant. I'm going to get this a court date for Monday the 22nd. If I got a warrant, I got a court date. I didn't know I was supposed to come back and show up on the 18th.
Yeah, you know how this stuff works.
I know. Well, he said we go to court on the 22nd, so I didn't think I was supposed to go to court.
Your obligation for probation was reporting every week.
Right, and
not when you want to report.
It wasn't when I want to report, Your Honor. It was like I came back. I was on my way. The tire busted. I sent her a picture of the tire. I didn't make it in time. She had a warrant out. My lawyer called me 2 days later on the Saturday.
You can talk about June 18th if you want to talk about June 18th and June 22nd, but I'm looking at this is continual for 30 years, 27 years as an adult. This goes one after the other.
I bumped my head a couple of times, Your Honor. I promise I can get it together. You
didn't bump your head. You keep beating your head against a brick wall and nothing changes.
I promise I can get it together, Your Honor.
Don't promise me, because I don't care about promises.
I got a lot going on, man. I got a lot going on.
I know you got a lot going on. Okay? And you're going to have a lot going on if you don't get your shit together.
I'm going to get it
and
together.
You don't listen. You haven't heard a word I've said.
I have.
You haven't heard one word I've said. Okay? Because they don't want you on probation. Okay? Because you don't put forth any goddamn effort to straighten out your life. You don't. You haven't. You don't acknowledge it, other than you don't need any drug treatment help. You just need grief help, right? You've continually said that you don't need drug treatment, right? Because I don't know what using this stuff recreational. You use methamphetamine recreationally? What the hell does that mean?
And I was going to get to that, Your Honor. And I didn't use methamphetamine. I bought them.
You didn't. Then why did it show up in your urinalysis? How did it show up? I had a lady here yesterday who's used crack cocaine for 40 years running, and she tested positive on probation for cocaine. And she told me, standing in that very spot, that she didn't use it. She was just in the room where it was, and she tested positive. So you tell me how you tested positive for methamphetamine, but you didn't use it.
I was going to say, man, when I went to the liquor store, when I got that wine from the liquor store sell pre-rolled joints. Like, I don't know if it was in the pre-rolled joint, but I did not knowingly just review.
I don't believe you.
I know you don't.
I don't.
All I can do is tell the facts, Your Honor. That's it.
Well, your version of the facts belie reality. Okay.
Yes,
What
sir.
liquor store did you go into that they sell pre-rolled joints?
Every liquor store in our neighborhood, the London liquor store, London.
What were you doing in a liquor store if you're not
That was
supposed
the day I
to
went to the cemetery.
What were you doing in a liquor store if you're not supposed to be drinking?
I know, that was the day I went to the cemetery, Your Honor.
Okay,
I
how did you see that was going to help you?
I didn't, Your Honor. That's why I said it clouded my judgment.
What have you done to address your mental health problems since 2022 when that happened to your daughter?
Nothing, like I said.
Nothing. Right? Your intention is to do nothing. Your intention is to come here, bullshit your way out of it, and continue on the way you're going. That's your intention.
Hopefully you give me the help I need.
I don't give help. Okay? I don't give help. I'm not a counselor. I'm not a drug counselor. I'm not a psychiatrist. I'm not a psychologist. I'm not a licensed social worker. Okay? I don't give help. I can't help people, especially people who can't help them, who won't help themselves, because that's your category. You won't help yourself.
Can I prove to you, Your Honor, and show you I can help myself? Can I prove to you one last time?
Wasn't that the point of putting you on probation in the first place?
Can I get one last time, Your Honor, to show you? I'll never be back. Can I get one last time to prove to you and show you that I can't help myself and I can't finish probation good?
See, that
Please.
you can talk about that all you want.
Please.
Okay, but you come in here and you tell me that you don't need help with your drug use. You just need grief help, which is complete. That couldn't be more.
Like growing up the way I went, man, especially with my family.
Before all the tragedies.
Before all the tragedies. Every day, like I'm talking to a person who was smoking every single day and drinking every single day. You know what I mean? Every week. I mean,
This
it
isn't
was circumstantial.
We're not here on the 50%. Plan is not for my benefit. It's not for probation's benefit. It's for your benefit.
I will do it again.
You completed IOP, and what was the result then? When did you complete IOP?
During 2025, last year.
Then why are you still using drugs?
Like I said, it was circumstantial. It'd be circumstantial, man. I get in my depression modes about situations. It ain't like I'm just waking up and just using.
Question I asked you a little bit ago. Why haven't you gotten help for it then? Because you didn't want to get help. You just wanted to go on your merry way doing what you're doing.
I do want to get help. I need help.
Well, then you should get help. That's why you were on probation.
I ain't your probation officer. It's like, and then when you do come to your probation officer with to try to get to talk to them and get to get them help, like I've been on probation a couple of times. With some probation officers, they give you, they try to give you resources. They try to give you help. Honestly, with Miss James, man, she is nothing. As a man, we be afraid to admit when we need help sometimes. That's me and some men do. Like, you know what I mean? I need the help, Your Honor. You know what I mean? And the way I'm gonna get the help is to come in front of you. Because I need the help, Your Honor. I need the help. But I'm not a bad guy. I'm not getting high every single day just saying F probation. I go to work every single day. I take care of my kids. I pay my bills. You know, I got an apartment in my name.
Where's your mother right now? In the hallway?
Out there.
How old is she?
My mom?
Yeah.
I'm 45. She got to be 63.
Okay. And who's she out there with?
That's my niece.
Why does she have your niece?
That's my brother's daughter.
So why?
She had my son too. My mom was my son.
How old's your son?
7-year-old.
She got your son?
She don't have him now. He with his brothers and sisters. He's starting back in school in 2 weeks.
And why is it on your mom to take care of all these kids?
No, she be watching my brother's kids sometimes.
Okay.
I mean,
so why is she every time that you're in the blue uniform, she's watching your 7-year-old? Why? Why are you doing that to her?
Exactly, and I'm doing that to him.
I know exactly. I know you are. I said, why are you doing that to her? Because you don't give a shit about her. You give a shit about yourself and the life you want to live. That's why. And you haven't done a thing to change it over the years. You've been to prison 6 times, and you pick up these 2 cases. No, these are only, what do we got? One's an F5.
Remember how when I caught this case? I remember I told you, like, it was them pills that I had in my pocket. I didn't even know. I stopped taking the ecstasy pills. I had them pills in my pocket when they found them. Like, I don't be in the streets no more. I haven't caught no more cases. I haven't had no contact with police.
These cases are only 2.5 years old. So don't tell me you haven't caught any cases lately. That's why you're here.
I have 18 months left, and I please, can you?
You've got 2 F5s. 2 F5s
Yes,
that you're here on. That's why I didn't send you to prison and kept you on probation after you kept violating. Because you had 2 F5s.
Yes,
but you haven't done a thing to help yourself.
Yes, sir.
since these cases. Not a thing. Now, at some point, you're not going to have to deal with me anymore. It may be sooner rather than later. Okay? But you're still going to have the same baggage, the same problems. You're not going to address them because you don't care to address them. Okay? You don't care to address them. If you cared to address them, you would have addressed them already. But you won't do it.
I will. I'm going to address them. Like, that's a hard pain. When you lose your daughter, that's a hard pain. I don't want to pain on nobody.
I'm not disputing that.
That's a hard pain. That's a wound that never ever heals.
Right.
I'm gonna get help. I'm gonna get the help I need, Your Honor. I bumped my head a couple of times, but I'm not a bad guy. I'm not, man.
This isn't whether you're a bad guy or not a bad guy. Okay. You're not here for beating somebody over the head with a baseball bat. Okay. You're here because you've got a 30-year problem that you refuse to address, despite being given the opportunities to address them. You won't do it. You haven't done it. That's why you're here. It's got nothing to do. You've told me 4 or 5 times you're not a bad guy.
Yes, sir.
And I've never said you're a bad guy. That's not the issue. Anything else you want to say?
I just ask that you give me one last chance. I promise I won't be in your courtroom never again. I will address it. I will address all my issues, Your Honor. I will. Like, I don't have, like I said, like, man, I can't really start my life back over. I'll be starting my life all over again if I leave. You know what I mean? My mom had to get all my stuff out of my apartment. I mean, like,
Whose fault is that?
And it's mine.
Right.
It's mine. I just ask you to give me one last chance. I promise to you, Your Honor. On my daughter's grave, man. I swear on my daughter's grave, I will get together. When I get out, if you let me out, I promise I will seek help that same day. The same day. I promise to you, Your Honor. I promise to you. I promise. I promise you won't see me in your courtroom again. I promise I will seek the help. It's just one. I need a little tweaking. That's it. I just need a little tweaking. I don't need much to get me together. I just need a little tweaking, Your Honor. I promise you. I will get it together. Like, what type of guy still go to jail for 30 days, come home, still have the same job, pay $32 an hour. I will get it together.
But that doesn't concern you because you still keep doing the same thing over and over again.
It was circumstantial.
What do you mean it was circumstantial?
Like, when I used it, was like I said, I ain't just using recreation. I'm using, like, I went to my daughter's cemetery, to my daughter's grave. Her birthday was her birthday fell on Father's Day. June 21st is her birthday. It fell on Father's Day. Man, I woke up, that hit me hard, man. I didn't celebrate Father's Day with my kids like we had planned. I went to the cemetery, to the grave, and sat with my daughter. And FaceTimed her mom. Her mom staying in Atlanta. FaceTimed her mom. Her mom talked to her for about an hour or two. It was circumstantial. Probation wasn't even on my mind. You know what I mean? That's what I'm saying. Like, it wasn't even on my mind. I wouldn't even think about that, Your Honor. Like, for real. I can get it together. I promise you I can get it together.
You have had plenty of opportunities to get it together, and you've refused to do it. All right, I've gone back and listened to, reviewed the pre-sentence report, the entire record, considered what Mr. Glenn has said, what counsel has said. I'm going to find you're no longer amenable to community control. 23-154, I sentence you to 10 months in prison with credit for 154 days. On 602, 10 months in prison, credit for 95 days. Costs are assessed on each case. The sentences will be concurrent to one another. Anything further, Mr. LeConte?
Your Honor, can I get the Neo Camp, please? Please, Your Honor.
Mr. LeConte, anything further?
Your Honor, again, I would reflect that I think it would be fair to give him a chance at NeoCap or OCOPS.
Well,
Please, Your Honor,
I've gone through extensively
please, Your Honor.
what has gone on with Mr. Glenn over the years,
Please, Your
despite
Honor.
the fact that Other judges sentence him to prison on 6 separate occasions on multiple. A lot of those sentences were concurrent. I put him on probation here. He's violated multiple times here. So that's the sentence.
All right.
Alrighty, friends. TCF Live on a Tuesday. Ellie, Barbara gave you $5 for treats. Do you want to tell her thank you? Just going to turn your back on her? That's rude. All right. I will thank you on her behalf. Thank you, Barbara, for the 5. Let's go to Judge McNally.
So did you waived your lawyer to when you were here on June 24th?
Yes, I did, Your Honor.
You still want a lawyer?
No, I do not.
I'll be happy to provide you with one at public expense.
Oh, thank you, sir.
Would you like a lawyer?
Oh, thank you.
You're sure?
Awesome.
You read the report?
No, I have not got a copy of it. No, it doesn't look good, Your Honor, but
Well, I gotta get you the report first.
It's right here.
You sit down and read that report, and I'll be right back with you, okay?
thank you.
Thank you. Morrow? I'll be right with you, Mr. Camilleri. I didn't even know you were here. I was told nobody was here. What time did you get here? A little late?
After talking to my client at 8:45.
That's all right, Judge.
Lateral, he's got a big problem with me anyway, so I want you to know that. Lateral Tyrone Morrow, 26W843636. Your name?
Sir, hold on.
You're charged with driving on a suspended. You have the right to an attorney. Would you like one?
I guess so.
Well, okay, you want a lawyer? You want a lawyer?
Do I need one?
It's up to you. I can't answer that for you. If you want a lawyer, I'll give you one.
Give me a lawyer.
Okay. All right, you go out in the hallway and we will set you up. Okay?
Okay.
Give me McCurdy, will you please?
You don't have a Powell file up there, do you?
How?
Powell?
No. Did I call it all case?
Well, let's keep an eye on Judge Dad. We will come back, but I want to go down to Florida. Wade Mercer is off today. This is Judge Dee Costello, and I want to get this in because every judge down there is different with how quickly they pull their feeds. So let's go there.
Good.
State Attorney's Office, okay. No? All right, there you go.
No, I'm in the courtroom.
Okay, have a PD?
Right here.
Okay, sorry about that. All right, let's go then. State of Florida versus Rodney Hicks. I'm just calling the order. You didn't have them, you sent them to me, unless you want them in a different order. Doesn't matter.
In order is fine, Your Honor.
All right, so Mr. Hicks, you're charged with aggravated assault. Let's see if I can figure this part out. Do you understand what the charges are against you?
No, ma'am, not really, but I do know.
Okay.
You understand them, you just don't agree with them.
Right.
Okay.
That's okay.
He understands.
Okay, fine. Do you understand what your legal rights are for today? Which are, you have a right to remain silent. You know that part? You
Yes, ma'am.
have an attorney who's standing next to you. And one will be appointed if you cannot afford one. You understand that, sir?
Yes, ma'am.
Okay. Any comments from anybody?
No, Your Honor.
Okay. So trying to figure some of this out. Okay. I see you have a few priors. Is any recommendation for bail from the state?
Just the standard bond. Since this is a third degree felony, I think normally what would be somewhere between $500 and $7,500. I'll let Mr. McDaniel say something.
All right. Mr.
I
McDaniel?
don't disagree with that, Your Honor. We just asked for a standard bond. I think the standard is 5,000.
Okay, 5,000 is fine. Returnable, what's he has to come back to court?
This August 4th would be his court date.
All right, August 4th, you'll see Judge then.
And Judge,
Yes.
no contact. Judge, we also recommend no contact with the victim.
No contact with the victim. That means no visits, no presence, no visit, no having anybody else call them, nothing. You understand? No emails, no texts, no phone calls, no nothing. Got it? All right, August 4th, after you make your $5,000 bond.
Belton Johnson.
State of Florida versus Belton Johnson. Sir, you are charged with grand theft. Do you understand what the charges are against you?
Yes, ma'am.
All right, fine. I'm Judge Costello. I'm just filling in for today.
How you doing, Costello?
I'm doing fine, thank you. They're treating you okay? You're happy. You're acting awfully
Ma'am,
happy.
listen. No, I ain't gonna lie to you. I'm sad as I don't know what. I don't want to be in jail. I just want you to show me a little leniency. I will never in life do it no more. Please, Your Honor.
Okay, wait a second. Let's not get into all that right at the moment. Do you understand what your legal rights are? Do you have any question about that?
Yes, ma'am.
You have a question or you understand?
I understand.
All right, fine. What says the state?
Your Honor, we're fine with the standard $5,000 bond in this situation, and we would also request he have no contact with any, looks like Walmart, but it may also be Lowe's. And no contact with Lowe's.
Okay, all right. Sir, bond is set at $5,000. Don't go to, no contact with Lowe's means don't go visit them. They don't want you.
Yes, ma'am.
Okay?
Yes,
So don't go in, don't
once.
call them, don't do anything, and come back to court. Is that again August 4th? I presume?
Yes.
Thank you, Your Honor.
All right.
Kristen Kenham.
All right. Kristen Kenham, you're charged with being a fugitive from justice from Pender County, North Carolina.
The waiver you want to sign right there.
Do you understand your legal rights?
Yes, Your Honor.
Okay, and what are you signing right now?
He signed his waiver, Your Honor, to go to the state of North Carolina.
All right.
And I went over all the rules with him, and he understands them. I don't think he has any questions.
Okay, is that correct?
Yes, ma'am.
Okay, so we'll notify, they will notify North Carolina, Pender County to come pick you up. Should we give them a return date in case they forget about him?
We'll bring him back in 15 days if they forget. That way we can make sure they hadn't forgot about him. But if they hadn't picked him up in 30 days, he's going to be released.
Of course. Okay. All right. So you understand what's going on then? Just want to make sure.
Yes, ma'am.
All right, fine. Thank you very much. That's it for today.
Brenda.
Okay. Brenda Major, you're charged with
Good morning.
petty theft. I think it was Lowe's, wasn't it?
Yes, ma'am.
Okay. Do you understand what your legal rights are?
Yes, ma'am.
Okay. You have any questions about the charges or for your lawyer?
No, ma'am.
Okay. She got a few priors. Is any recommendation on this one? From the state?
Your Honor, based on the discussions with the defense, this looks to be her third petty theft. It could qualify as a felony. The state has actually extended an offer for 90 days jail to resolve the case today. If she doesn't want to resolve it, then we can just put it on the August 31st arraignment date. But we would ask for a standard first degree misdemeanor bond and the condition no contact with Lowe's.
Is that like $1,000?
I think it's about 2,500.
Okay, because I don't know what your standards are anymore. Okay. Okay, so
Well,
what do you want to?
1,000 is the standard, but I think that this court always does 2,500. But we have no objection to that.
Okay, so you want me to go ahead and set your bond, ma'am, and have you come back to court on August 31st, county court?
Yes, ma'am. Yes,
Subject
ma'am.
to- They're going to review it and they may file it as a felony. Okay. Okay, so your bond is 2,500. Do not go to Lowe's. No contact whatsoever with them. Come back to court August 31st.
Thank you.
Wendell Claxton, Your Honor, we do have an agreement on Wendell Claxton's case.
Okay.
Please.
All right. Mr. Claxton, you're charged with having no driver's license or never having a driver's license. Apparently, there's an agreement between you and the state. Is that correct?
Yes, Your Honor.
Let me have somebody announce it.
Your Honor, I spoke to Mr. Claxton. He's going to plead no contest to the charge of driving without a driver's license, understanding that he's going to pay a $400 fine within 60 days. If he fails to pay that fine, he'll do 10 days in the county jail. If he gets a valid license before he pays the fine within the 60 days, the fine would be $300. He has signed his plea waiver form, waiving his right to jury trial and call witnesses.
Okay. Is that what you want to do, Mr. Claxton?
Yes, ma'am.
All right. Raise your right hand, please. The best you can. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right. So
Yes, Mrs.
put your hand down, get comfortable as much as you can. You understood what your lawyer said, is that right?
Correct.
You think that's the best thing
correct.
for yourself and under these circumstances?
Yes, ma'am.
Okay. You had plenty of time to talk to your lawyer?
Yes, sir. I'm okay with it.
All right, good. So you're satisfied with his services?
Yes, ma'am.
And you're ready to get out of jail?
Yes, ma'am.
Okay. Did you read over the plea form and understand it, sir?
Yes, I do understand it.
Okay. Any questions about your legal rights?
No, I don't have any. I'm okay.
Okay. All right. Then anything else you want to say?
I don't know. I just need to get home so I will get my medicine.
Okay.
I'm a diabetic and I have kidney problems. So I have been my medicine for 2 days. So I'm a little off. So I'm all right though.
But you're all right enough to go through with this, is that right?
Yes, ma'am.
Okay. Then you're adjudicated guilty. You are required to pay a fine of $400.
Yes, ma'am.
In 60 days.
Yes, ma'am.
Or if you fail to do that, you will serve 10 days in the Jackson County Jail with credit for 1 day, 2 days. When have you been in?
I think it'd be 2 days now.
All right, 2 days credit. Hopefully we don't have to do that. However, if you get a valid driver's license within that period of time, the fine will be reduced to $300. So if you get a valid driver's license by chance, you need to present it. You come to the sheriff's department, I guess, and present it to them.
Okay.
Okay.
Okay, I understand.
All right. Anything else then? Okay. We guess we have to take your fingerprints, don't we?
So,
Adjudication?
she adjudicated, so that's fine. So, okay. Nothing else, Your Honor.
All right. Very good. How about tomorrow? We gonna have fun tomorrow too?
Absolutely. I look forward to it.
We will.
All right. Good deal. Got the computer.
See you
on.
tomorrow.
Oh, Jail's got a question.
Yes.
Do you want me to send this where we send the waiver? Do you want me to send it for you to sign where we send the other paperwork?
Whatever you want to do, you can send it, but don't send it to the Gmail account. You should be using my official account, which is Costello.
Okay.
So,
JD. Judge
scan it and send it to PD or to the, not the PD, but to the 14 Judicial
Okay.
email address.
No
Need it,
problem.
I have it. I can get it to
Okay,
you.
I think I got it.
Yeah. So just scan it and email it.
And can you copy Ms. Jones, please? Dale.
Copy.
All right, friends, that's Judge Costello, who has been on the bench for forever and a day. Ballotpedia says she's actually retired, so I think she just does substitute work at this point. Alrighty, but again, I wanted to get that in because you never know how quickly these judges in the various courts will delete their feeds, so I didn't want to sit on it. But let's go back to Judge McNally now.
Attorney John Camilleri, we have Kenneth Randall, 30, sir.
Your name, sir? So I want to make sure I got this straight. Defendant on May 24th was arrested for operating while intoxicated. But guilty to operating while impaired on June the 24th. He also had a arrest date in front of Judge Hessen on April 19 of 26. He was arraigned on that on June 25 of 26. So I just want to make sure I'm understanding this correctly. He goes out, gets one April 19th. I arraign him June 24th. I'm sorry, April 19th, but he goes out, gets another one May 24th. I have the second case.
Correct.
Apparently, the team decided not to accept him in the sobriety court. Judge Hessen had referred him. And then I heard that yesterday she's going to continue his bond conditions.
Correct. However, Judge Hessen adjourned the sentencing that was yesterday until August 12th at 8:45. He had an intake for sobriety court yesterday. They're going to approve him, I suspect, because Judge Hessen, my client, McCurdy, wants to enter into sobriety court. She believes it's a good thing for him.
Did he pop the bird when he was taking a SilverLink device?
Pardon me?
When he was blowing into his SilverLink, did he pop the bird to somebody? Did you do that? I'll call in the probation officer if I need to. That's what I was told. If she's wrong, I'll apologize. Did you do that?
Yes,
Nice.
we talked about it.
I never talked about it with you.
No,
I was told about it yesterday. I don't get it. Who do you think you are? Popping the bird to the SilverLink people? Because you went out and picked up 2 drunk drivings at the ripe old age of 18? Who do you think you are? I need to know. I wish I could go through life with that kind of confidence. I really do. I really do. Every time I screw up and I'm called on it, I can start popping the bird at people. You're 18. If you're running Ford Motor Company, that still doesn't make you able to do that. Do we understand one another?
Yes, Your Honor. Sorry, I do.
It wasn't on my case. But you play games with me like that on this one, you are going to have a big problem. Do we understand one another?
Yes, Your Honor.
What's he thinking? I'm serious. What is he thinking? This is not boys will be boys type thing. He goes out and picks up 2 within 5 weeks, and then he's that arrogant? Tell me you're an All-American in something, and you're going to Harvard to play football or basketball or baseball because you're on an academic scholarship, but you're a great lawyer. I mean, a great student. Tell me that. I want to hear that. I want to know that. I want to know that we're at least not wasting our time with somebody who's going to Harvard or Yale. Jeez. Imagine. If I was 98, I wouldn't think of doing such a thing. You're 18, you're cocky. Who's this? You better make them not so cocky. Cockiness gets us in trouble. Arrogance is our biggest enemy. I don't even know if I should sentence him right now. You know why? Because I don't want to sentence him based upon how I feel right now. Don't say anything. Don't say a word. Do not say a word.
So, Judge, I thought you might adjourn the sentencing.
I'm not gonna be a party to him being in sobriety court. I knew you were gonna answer that. That's why I wanted to bring this up, because he's not gonna act like that. He's not gonna act like that. People that are that arrogant have a 0.0236% chance of succeeding in sobriety. It's my experience. I've been doing it a long time. I have a good mind to send you to jail today. Then we'll see who's popping who the bird.
Well, I suggest that
your client get himself under control before he really agitates judges.
Well, that would be a good thing. I have talked in length about with Ken I think I told him I harp too much. But Judge, here's some of the stuff I write to him. I tell him, look, this is the circle of people who companies want to employ. You gotta get yourself in the circle. Now, you're not gonna get in the circle unless you have a college education. This is the most likely. Or you get some qualified skill. To get one of these two takes patience, intelligence, and get rid of the ego. You're not gonna get in the circle if you have any of that, you know, so.
And he picked up, let's not forget, he picked up 2 drunk drivings before he even graduated and was not even legally able to consume alcohol. What was the breathalyzer or blood draw in Judge Hessen's case?
0.10.
I cannot believe when he got arrested on the other one, that he went and did the same thing. I just cannot believe that. Go ahead. I'm gonna sentence him today. I'll listen to anything. I'm gonna be fair with him.
Okay.
I mean, I'm gonna still treat him like he should be treated, but he's gonna be on a really short leash with me. Have you had a chance to review the report with him? And are there any material additions, corrections, or deletions? And by the way, he's on a sober link right now, right?
Correct.
I ordered that.
Correct.
Go ahead. I'm sorry. Are there
I get it, Your Honor. Judge, we've reviewed the substance abuse screening. It is truthful, it's accurate. Judge, there's no doubt, but for me, 34 years of practicing law, I've done a lot of cases. I remember you saying, John, you're here more than any attorney pre-COVID. So I've never had a case where I've had an 18-year-old or Darren or close to 18, 2 drunk driving tickets in such a short span. Sure, I've had 30 and 40-year-olds with 2 drunk driving tickets in 6 months. However, so I understand the gravity of what's going on here. I know you do. I've talked to my client about it in length. I'm not the kind of guy that shuts his mouth anymore after this many years of practicing law. He passes me on the road just like he passes everybody in this courtroom, and I don't want him to kill any of my loved ones either. So I don't need the money that bad to tell a client what they want to hear. I tell them what I think I should tell them. Your Honor, however, I don't know if Kenny's the kind of guy that is ego, immature, all wrapped in one, and he doesn't drink a fifth a day, or if he's drinking a fifth a day, depending on what type of problem he has with alcohol. You can have a problem with alcohol being immature. You don't have to be, let's say, attached and addicted to it to have an alcohol problem. You could be discounting the risks and not be, let's say, psychologically addicted. You still got an alcohol problem. He's very young. He lost his dad when he was 14. He doesn't. His mom is trying. He works with his mother, and he has been for months. He works Monday through Friday, 8 to 4. He is in an intensive guidance outpatient program at the guidance center. He goes 3 times a week, 4 to 7. He's been on the sober link since June 24, all negative. He is going to AA 3 times a week.
Have you seen proof of that today?
Not today.
Show your lawyer your proof you've been going to AA.
He not today. I haven't seen it.
I mean, I want you to show it to your lawyer right now.
So, and he'll show it to us, Your Honor. So he's doing all the necessary steps to learn about alcohol. However, I agree with you. 2, in a very short period of time, I'm much more of a guy, proof is in the pudding. And when you get 2, that's very concerning. However, he has shown the discipline to abstain from alcohol and take the necessary steps to get cognitively realigned in his head about the risks of alcohol and the use and the abuse. At that point, Your Honor, he took a tongue lashing from Judge Hessen yesterday. We had our
good.
He had her sentencing. She adjourned it to the 12th. He will be on sobriety report. From from what I can see, well, I asked Judge Hessen if I could inform you, is Judge Hessen inclined to put him on sobriety court? She said yes. Tell Judge McNally, you can state that to Judge McNally. She is inclined to put him on sobriety court. After all, he is going to be doing pretty much the same, if not more, if he wasn't on sobriety court. But Ken, my client.
I thought they were gonna put him through another bond phase.
Pardon me, Your Honor?
I thought they were gonna put him through another bond phase for the next 4 weeks. Is that not true?
No, bond phase just until the next sentencing hearing. So we have, 3 or 4 weeks until August 12th. So bond conditions were continued. He has to continue with sober link. He has to continue going to the guidance center. He has to continue, of course, abstaining from alcohol, et cetera, et cetera.
Go get your AA verification.
Your Honor, continuing, again, yes, he's very mature. The instance you mentioned, I saw in the previous pre-sentence evaluation, if I may approach her.
I don't need you to approach. Has he gone 3 times since I ordered him to back on June 24th? There should be about 12 or 11 of them.
There are 6.6, 6.7.
Okay, I believe you. You don't have to
Yeah.
read them.
He's got them.
Go ahead.
So I brought it up myself. I said, he gave the finger to camera. I've never seen that in 34 years of practicing law. Kenny knew what I told him, complete immaturity, baffling to me that you think that. I don't know what to think about that, actually, Your Honor, especially in court. I don't think I would tell you what I think about it. So it baffled me. I don't know the psychology behind giving the camera the finger. But it's surely an indication to me that Ken is really immature. And I did tell him,
At a minimum.
do that in boot camp, see what happens.
All you gotta do is go out and get one more of these between now and 2100 and you're gonna be a felon. Do you understand that?
Yes, Your Honor.
You got 75 years. You have to make sure you don't get another one or you're gonna be charged with a felony.
Talked to him about that, Your Honor. I talked to him about the peer pressure. I talked to him about, look, peer pressure doesn't go away, even at my age, in my 50s. The peer pressure is there.
Were you in front of somebody when you popped the bird?
What?
Were you in front of somebody when you popped the bird? You just did that for what reason? I wanna know. I'm not done talking about that.
When I just woke up.
Just woke up. Oh gosh, I didn't want to keep you up. We didn't want to keep you up. What time was it?
Sure, I forgot what time I do that one.
I went in length with Ken about these cases, Judge. Again, there's a long future for Ken. He's only 18. There are going to be hurdles, and I hope with the realignment and the education that he never forgets this moment and the moment in Judge Hessen's courtroom. Life is not but a bundle of memories, and memories make a difference. And to me, I'm a big believer in remembering and then taking a left instead of a right when the moments come in life that you have to make good decisions and you remember where you're at today. I'm a big believer in that. And I do have faith in Ken, but it's gonna be a long period. But he's doing everything he's supposed to do. Proof will be in the pudding. I hope the court gives him a chance. Avoid jail. I do believe with the restrictions that he is going to be put on, he's going to be in a form of lockdown. I mean, he has to continue working in the bar. He's been there for months. He's going to have to continue the guidance center 3 to 7, 3 times a week. And he's gonna have to continue doing things you're gonna require him. Hopefully court program, community service, more education. His life for the next 2 years, he has to surrender to the notion that it's given to something greater than himself, and that's called sobriety and realignment. I mean, his body is not gonna wanna do all these things, but he's gonna have to learn, the mind is gonna have to learn that it's for his betterment. So avoid the friends, you're done with that. He's gotta surrender.
Remind me, who were you with at the time you picked up this drunk driving?
One of my friends.
They were all 17, 18, and I was wondering what the heck were the parents doing, because the parents were home. And I brought that up with Ken, and I wondered why the police didn't, there was a reason why.
Wait a minute, you guys were drinking at somebody else's house?
That's right.
Nice. Well,
So I realized why the parents weren't somehow involved, not his parents, but the parents who were providing,
okay.
and I figured it out.
Somebody was providing you alcohol, an adult?
Yes, Your Honor.
Nice, nice. Really, really good.
I figured out why they were not involved, and somehow with the PD, because Ken was driving.
Really good. I'm just so glad that somebody would think that one through and say, we're gonna provide our 17 and 18-year-old kids alcohol and let them go out and drive and just hope they don't kill somebody or themselves.
But that's
smart. I mean, that's a good gambler.
But that's no
They're
excuse.
betting $100 that, I don't know.
But that's no excuse, Judge. He's an adult.
No, I get it. I'm
I
not
know.
making excuses for them. And I'm not making excuses for him. I just question the intelligence of some, let's not say intelligence. Let's say common sense of some people. What kind of common sense would cause you to think that that's okay? They're not able to drink. You're giving them alcohol. Somehow they manage to leave driving a car. I'm never amazed. Just not amazed. Go ahead. Anything else anybody wants to say?
Just want to say I'm sorry, Judge. I stopped hanging around the same friends. I do want to change for the better. I do.
Turn around and look at your mom. Your mom was looking straight ahead. I watched her. You don't want to disappoint your mother.
I will change for the better.
You do not want to disappoint your mom. You'll regret that. If you don't regret that and you disappoint her, well, then there's something even bigger wrong with you. 2 years probation. You cannot leave, and I'm going to treat this. I'm running a tight line here in this sense. If you get into sobriety court, Judge Hessen's willing to accept you. I'm going to take into account the fact that this is first in time in terms of sentencing. If she accepts you, you're not probably going to go to jail there, but I will tell you, if you do not comply with my probation here, the probation order that I'm extending it, in which case she's probably not going to accept you anyway. But even if she does accept you, if you don't comply with probation after that, you are on such a thin leash. You have no idea. 2 years probation, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, your place of employment or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs and ETGs as follows. Weekly for 4 months. I don't know how you're going to pay for that. I don't want your mom paying for that, but you're going to have to pay for that. Now, if you get into sobriety court, that will run concurrent and the grant will take over. But that's between you and Judge Hess. Weekly for 4 months, and then bi-weekly for 8 months if you're clean, and then monthly. You're to attend AANA 3 times a week until you're in an intensive outpatient treatment program with aftercare. I heard what your lawyer said. He told me you're in intensive outpatient at the guidance center, I think you said, right?
Correct.
And that's fine if you're already in, and you're in a program that's qualifies as intensive outpatient treatment, you're not going to have to go to AANA any longer until, and at the end of treatment, in which case it would be considered aftercare. Attend the victim's impact panel. You're to be on a SoberLink device until October the 22 of 26. You're to serve 8 days jail credit, 1 serve 7. I'll let you serve those on the court work program. The court work program, there is a $35 a day charge for that, for a total of $245. You're gonna pay fines $300, cost $250, cost $225, 75 victims' rights fee, $50 justice assessment, $650. Probation fees are $480 for 1,030. Cost of recovery is $150 for 1,180. Screening fee, did I already count that? Let me double check. 650, 950. 1,030, 1,180. Screening fee is $60 for 1,240 plus your court work program fees. Your total is $1,485. Would you double check that math, Heather? If you violate your...
Yeah, I did get something different. I got 1,585. You said cost was 225, correct? And fine
I think
was
you're
300.
right. I think you're right. 1,585. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. You may be eligible for early discharge in 12 months per statute. You get everything done, you stay out of trouble. In this case, you'd be released. Do we fully understand one another? You got to grow up. That's all I'm going to say about it. And I expect full compliance. If I don't have it, well, it's not going to be pretty for you, okay? I'm going to let him pay. I understand he's a kid. He doesn't have the money. How are we going to do this? How much can he afford to pay per week or bi-weekly?
Well, he's working, making about $350 to $400. He could pay $150 a month, right? Yeah. Okay. If you could.
Yeah, I can do that.
Oh, thank you, Joe.
150 per month beginning August the 8th. How's that? Is that okay? If you don't have the money and you need more time, it's not a problem. Call the court. We'll go on Zoom. I wish you well. I hope you're learning from this. Good luck. Thank you.
Thank you, Judge.
Sure.
So I've got to say, friends, in the almost 2 years now that this channel has been around, I can't recall ever seeing a time where we had an 18-year-old with 2 drunk drivings already. I don't think we've ever seen it that young. If I'm wrong, let me know, but I can't think of a time. Alrighty, let's we'll keep an eye on Judge McNally. Let's rotate back down to Judge O'Donnell, though. New contestant there.
Thank you, Judge. Before you this morning is case number 25 CR 1189, Captain, State of Ohio versus Antonio P. Howard. Judge, the Lake County Grand Jury indicted the defendant on February 27th of 2026. The defendant is present today in court with counsel Mr. LeConte. It is the state's understanding that the defendant is here today as he wishes to plead guilty to 3 of the counts contained in the indictment that was issued on February 27th of 2026. Those charges are count 1, identity fraud, a felony of the 5th degree, count 7, a lesser included of count 7, Judge, that being attempted failure to comply with an order or signal of a police officer, a felony of the 4th degree in violation of ORC 292302, and count 8, tampering with records, a felony of the 3rd degree in violation of ORC 2913.42A1. Should that plea be forthcoming, Judge, after your conversation with the defendant, is the state's further understanding the defense intends to ask for pre-sentence investigation in this matter and defer sentencing?
All right, Mr. LeConte.
Your Honor, we've had a chance to go through all the discovery, to analyze the case. My client and I have had a lot of discussions about the case. I've had a lot of discussions with the state. We worked out what we feel is a fair plea deal, and we're prepared to go forward with it. My client has reviewed the written plea agreement, understands that I've gone through it with him, and we're ready to proceed.
All right, thank you. Mr. Howard, how old are you?
I'm 38. I'm sorry.
You can remain seated.
Oh, okay, fine.
How old?
I'm 38 years old, sir.
How far did you go through school?
Oh, I graduated from Shaker Heights.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir, I am.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
I got prescription.
What do you got there?
It's a generic brand of the Wellbutrin. I can't really pronounce it. Buproppion.
Okay, when did you last take it?
I didn't take today, this morning.
All right, does that affect your ability to understand what's going on here?
No, sir. No, sir. It's to help me.
Did you get a copy of the indictment in this case?
Yes, sir, I did. Received an email from my attorney.
And it's my understanding you're going to plead guilty to count 1, identity fraud, a felony 5, the lesser included offense in count 7, the attempted failure to comply, a felony 4, and count 8, tampering with records, a felony 3, and then the remaining counts would be dismissed at sentencing. Is that your understanding?
Yes, sir.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, stop me. If you want to talk to Mr. LeConte some more, let me know and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, I do,
Are you
sir.
waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
I am, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
I do, sir.
Are you waiving that right?
I'm waiving that right, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
I do.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
I am.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
I'm waiving it.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
I do.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
I'm waiving it.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
I do.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of the transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
I do.
Do you have any questions about any of these rights?
No, sir, I do
Do you
not.
still want to plead guilty to these charges?
I do, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, sir, I do.
You understand by pleading guilty to these felonies, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
I definitely understand.
In count 1, identity fraud is a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
The lesser included offense in count 7 is attempted failure to comply with the order or signal of a police officer. It's a felony 4 with an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
I do, sir.
Count 8, tampering with records, is a felony 3. It carries a 36-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes, sir.
Now, I could give you a consecutive sentence, that means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 66 months and a maximum fine of $17,500. Do you understand that?
Yes, sir, I do.
Do you have any questions about the penalties?
No, sir, I do not.
Do you understand that if a prison term is imposed in this case, that upon your release you might be placed on post-release control for up to 2 years under the parole authority?
Yes, sir.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
I do.
If the violation were a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
I do, sir.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand that if a prison term is imposed, in this case, you are eligible for judicial release?
Yes, sir.
I could place you on community control for up to 5 years, but if you violate the conditions, I could send you to prison for 66 months. Do you understand that?
I do.
Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
I wasn't promised anything.
Has anybody promised you what I would sentence you to in this case?
Nope, I wasn't promised none of that.
Do you understand, at the time of sentencing, I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
I understand, sir.
Have you had enough time to talk with Mr. Lacanti before pleading guilty today?
Yes, sir. Yep.
Has he discussed everything about your case and answered all of your questions?
He definitely did.
Are you satisfied with the advice he has given you?
I definitely am.
Have you been threatened or coerced in any way to plead guilty today?
No, I was not.
Are you freely, knowingly, and voluntarily entering your guilty plea?
I am, sir.
Do you have any questions at this point?
I don't have any questions, sir.
All right, Ms. Naroda, if this case went to trial, what would the evidence show?
Your Honor, had the state proceeded to trial in this matter, the state would have brought forth the following facts. And that was, on or between March 8th and March 30th of 2021, the defendant presented at Buick GMC in Painesville Township. The reason for his appearance there is he brought his vehicle in for repairs. When he went to the Buick dealership, or the GMC dealership, he identified himself as Anthony Jeffries and requested that the dealership make repairs of his vehicle. Initially, he put down a cash deposit and was ultimately informed by the dealership that the repairs would be substantial, somewhere in the $9,000 or $10,000 range. And as a result of that, arrangements had to be made for additional payments. Within, I would say, a week's time, the defendant had a loaner from the dealership and communicated with the dealership, and eventually fraudulent payment was made for the repairs of that vehicle on his behalf at that time. And the dealership contacted the Lake County Sheriff's Department and contacted the defendant and requested he return the loaner. And on March 29th or March 30th, the defendant did present again at the dealership with the loaner to pick up his vehicle. And once he arrived, he saw the Lake County Sheriff's deputies there, and he left in the loaner vehicle. He ultimately stopped the vehicle not far from the dealerships on Jackson Street, almost in the city of Painesville, and was taken into custody at that time. However, when he was taken into custody, he once again identified himself as Anthony Jeffries. He interviewed as Anthony Jeffries. He signed documents in the jail and at the Painesville Municipal Court as Anthony Jeffries. It wasn't until the probation officer for Anthony Jeffries, who resides in Georgia, contacted the Lake County Sheriff's Department that our agency became aware that he was not Anthony Jeffries but Antonio Howard.
Thank you. Mr. Lacanti, anything to add to those facts?
No, Your Honor.
Mr. Howard, did you hear what Ms. Naroda said, that the facts would show if this case went to a trial?
Yes, I did, sir.
Are those facts true?
Those facts are definitely true, Your Honor.
All right. What is your plea to count 1, identity fraud, a felony 5?
Guilty, Your Honor.
What is your plea to the lesser included offense in count 7, the attempted failure to comply, a felony 4?
Guilty, Your Honor.
And what is your plea to count 8? Tampering with records, a felony 3.
Guilty, Your Honor.
All right, Mr. LeConte.
Date here or sign here? 22nd. Yeah.
For the record, Judge, I am handing you the written plea of guilty. The defendant has signed it in the presence of his attorney, Mr. LeConte, and I have signed on behalf of the state of Ohio.
All right, Mr. Howard, is this your signature on the written plea of guilty?
Yes, Your Honor, it is.
Did you sign it voluntarily?
Yes, I did, Your Honor.
Do you want me to accept your written plea of guilty?
Please, sir.
All right, I'll accept the written plea of guilty. Defendant was present. Mr. LeConte advised of all of his rights in a knowing, intelligent, and voluntary waiver. He understands the nature of the charge, a consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept the plea of guilty and find him guilty of count 1, identity fraud, a felony 5, a lesser included offense of count 7, attempted failure to comply, a felony 4, count 8, tampering with records, a felony 3. I'll refer this for a pre-sentence report. Who prescribed that medication for you?
My doctor, what's her name?
What's it for? What's the condition?
It's to help. It's supposed to help me lose some weight, maintain the withdrawals from stop smoking. Like, cause I guess it was supposed to be explained to you what was going on, the circumstance. Just because you guys handle things different under the circumstances of my past.
Okay.
It's just helped me with withdrawals, and it helped me lower my cholesterol with losing some weight because I had gained a lot of weight.
All right. I'll also refer this for a drug and alcohol evaluation. Sentencing will be September 10 at 1:30, and the bond is continued. Anything else, Ms. Naroda?
Nothing further, Judge.
Mr. LeConte?
No, Your Honor.
All right. When you go over to probation, show them what you're taking so they know that, okay?
Okay.
All right.
Thank you so much, sir.
All right. Thank you, Your Honor.
Alrighty, friends, hour 2 of TCF Live on this Wednesday. Let's get out of the Midwest. Let's go down to Texas, Judge Stevens.
It's what?
Brenda.
Brenda. Okay, so it's 3 syllables in it. Wow. And Mr. Turk is here. You've got the state jail felony of creditor debit card abuse. And what are we going to do? It's $47.65, huh?
Yesterday, I filed a motion to increase her bail based on the fact that there's been another accusation of a theft from June 27th. And that came up the last time she was here, and we reset it here. It's still in the process of it being filed. I've talked to our intake, and I don't understand why they haven't actually processed it formally, but it's in our office. I know the charges have been accepted. It's just not gotten to the stage.
Details about it.
This is the probable cause, which has been provided to the defense. But
is this a copy for me?
Yes, sir.
The file?
You can have that.
Thank you, because I'm going to highlight.
You said you filed that motion yesterday, didn't you?
I did. I showed that it was accepted.
Okay.
But
I just didn't know
Yes, ma'am.
this morning.
Yes, ma'am.
So
Let me print that
in
out.
case
I have the motion for you, Judge.
I have it,
I do know we're going to prosecute that matter. We're going to do that as an organized retail theft. It's the PC is as engaging, but there's a separate portion of the theft statute that we're going to process on organized retail theft.
What is that? For?
Same, it's still the same level of offense. Yes.
I'm older. That's still 3 people to get that. Within 2 months. I have to go look. I was looking at
Yes, sir.
Yeah, they've already changed it over to organized retail theft. It's the last one in blue.
Okay.
But it's not actually been.
Yeah, I looked yesterday. I didn't see any filings. But...
Okay.
Are you, sir? Not this one.
All right, I'm looking at a probable cause affidavit prepared by, I guess it was, it's a
Officer Powell with BPD, Judge.
Beaumont PD.
Yes, sir.
Okay. And this alleges that on June 27th, which is about 3 to 4 weeks ago, at 6:37 in the evening, officers were dispatched to Walmart on Dallin Road here in Beaumont, Texas, in response to a theft, and 3 females were walking in the wooded area. They made contact with the females who dropped several black bags and 1 blue bag. They were detained, including this defendant who's in front of us today in this case, and Walmart loss prevention claim they had observed all 3 females conceal stolen property inside various bags before leaving the store, and the estimated loss was about $300, and they wished to file charges. Again, this was on June 27th, 2026. And these 2 cause numbers pending before the court, 26C0747 and 748. This defendant, this Boudreaux here, is charged with creditor debit card abuse, state jail felonies, and it is alleged in these indictments that she committed these crimes on or about December 10th of 2025 and on or about January 24th of 2026. The defendant posted a bond. And by the way, these earlier indictments were filed April 29th of 2026.
Okay.
About a month later, in May 28th of 2026, the defendant is posting a bond of $4,000 in each two bonds of $4,000 each in each of these two indictments that had been filed. And then again, she posted on May 28th of 2026. And then she is arrested a month later after posting bonds on these two cases with a third crime of the theft at Walmart. So there is a motion to increase the bail. And I have in 747, but she's also charged in 748. I don't have a motion.
Judge,
I filed it in both, Judge.
I can print the one for.
What's the state asking for here?
Judge, we just have an increased concern about the safety of our community because of a continued violation. We feel that the bond, obviously, it's set. It's not got our attention. We need to have some increase in some.
What are you asking? What do you think is fair?
What was the bond amount on these, Judge?
4,000 each.
I would suggest 15,000 on each, Judge. Minimum.
Go ahead.
Judge, my understanding from what's coming around, I know that the two existing cases, I have those, but this new one is, I haven't gotten much other than the PC on it. It's essentially a shoplifting allegation. Would you mind if I have copies? I didn't get one. Sure. So.
Of this?
I don't have a copy of the
Is that what you want?
No, I don't have a copy of the motion.
Oh, okay. Do you want one for each case or
Just wanted to do the same thing.
Yeah.
But my understanding, none of these crimes are violent. This isn't a to be because I don't know that Mrs. Boudreaux can afford $15,000 per case, which.
There's a way to avoid this.
Well, but it becomes this shouldn't be an instrument of oppression or a penalty. It's a bond. So
well,
none of these are violent cases.
What does it say when someone is arrested, indicted on 2 felonies, and then within a month is committing a similar type of felony offense? Or this is a theft. I don't know how it's going to be filed, but it's another crime of moral turpitude.
And then also to know that she starts a job today.
Yeah, maybe. But there's a way to avoid all of this, is to be honest.
Well, Judge, I think as the facts being bear out with this new case, having talked to my client, I think it might show that she was with a group that doesn't necessarily make it better. But I think that the group that she was with may have been the perpetrators more so than she. Again, that's going to hopefully bear out in the case. But as it stands here today, I think she was just with the wrong people. I told her earlier that these are not her friends. These are people that are getting her in trouble. So friends don't get you in trouble.
No, but your choices that you make is what makes you responsible. And somebody who had just been through the system, arrested, had to post bonds, I would think they would be on high attention about dealing with others. And let's see, there's a
I think it's important to note on that PC, which is a conclusory statement by the police, that Ms. Boudreaux was with the group. The other 2 girls that she was with were the ones that were actually had stuff on their person as well.
I'm sorry, the loss prevention claimed they observed all 3 females conceal stolen property inside various bags.
Conclusive statement, but if you court reads further, they'll note that the police officer making the arrest found stolen items on the other 2 and not Ms. Boudreaux.
Anything else?
No, Judge.
Your bonds are revoked. Warrants are issued for your arrest, and you must post $15,000 bond in each of these cases. Plus, you will be on home confinement because we don't trust you going out and continuing to apparently commit the same kinds of crimes of theft. It costs everybody else who's honest. for the loss. You must be on home confinement. You have to have a GPS device. You can only leave home to and from work in the most direct route possible, to and from court, to and from your attorney, and to and from to get food. And otherwise, if you fail on that, your bonds will be revoked, and there probably won't be a bond next time, because these are, you're required to follow the conditions of bond. And the last condition of bond that you were given before you were here for this new case was don't commit another offense. So
To be clear,
honesty is always a good thing.
to be clear, it's 15 on the 2 credit card uses.
In each of those, yeah, that's $30,000.
Thank you, Judge.
Anything else? What's next? Next event? Set it for trial or this?
They've got to file the new case so that maybe we can work something out on all of them.
Give us another announcement date and I'll make an
announcement in
4 weeks, Judge.
Is that
just to
good?
be
4?
safe.
All right.
You can post it. You just have to do.
And those are both cases, 747 and 748, the orders. Okay, I have Steve Savoy. Steve Savoy. Hey, Brent, what are we doing, Steve?
Judge, we're working on that. Unfortunately,
Where's Steve Savoy?
Signed DA on that one to work on something.
Where's Mr. Savoy? Is that him? Come on up.
We haven't referred in the case that Mr. Savoy is not keen on.
Is that him?
That's it. And so at this point, if
the day a defendant comes in here giggling and happy about what's happening in here, I'll jump off the bridge. I'll jump off the Orange Bridge, because it just doesn't happen. It just doesn't happen. That's why it's a safe bet for me. But he's charged with a state jail felony. It looks like defendant claimed the child was unsupervised. Something with neglect, I think is the way it says, child abuse / neglect, false statement with intent. Anyway, it's a state jail felony, which carries with it up to 2 years in the state jail. And this was involving a 4-year-old child.
in essence, Judge, the state's alleging that Mr. Savoy falsely reported child abuse. It's in a basic nutshell, very reductive, that he was not the one committing the offense. You know, trying to be considered.
Have you ever been convicted of a crime before, ever, sir?
Small petty things. Yes, yes.
Well,
No, I'm talking about felony.
No,
I think he has some deferred, successful deferred and misdemeanor, Judge.
Okay, well, this one's, it's hard to figure out, but I think I've got it. All right, this was an announcement today, so what are we doing?
Trial, I guess, Judge.
All right, it's a trial, but on the trial docket, that's what we shall do.
Continue.
And let's see. Mr. Walker, you ready?
Yes, sir.
Get your reset.
I'll just email your attorney.
Thank you.
Pretty Jack.
I just need to get his fingerprint.
His name.
There you go.
Lane, his, there we are.
Terry. You like to.
Chad.
Yes, sir. That's one.
I'm here, sir.
Good issue.
You need to go right there first and she'll swear you in and then we'll come right back.
You swear on front to tell the people how to the end of the truth that you got. Okay, eat up your right thumbprint, right thumb.
I didn't get you anything.
That's it. Not right there on one.
That'll be back.
Oh, okay.
I need to start with that. Again,
Christmas is coming.
Yes, sir.
place it flat right there. All right, one more time. I'm gonna press down on it and see.
You could use a little snow right now.
That's better.
Wait,
There you go.
What's happening?
Stand for the judge.
My dad could make me laugh. He used to say when it was hot like that, he could say, I know hell is going to be hot. I just pray it's not humid. He said, I can take that dry. This is just, this heat is just hard to deal with. 25 CR 1873 is called, the state of Texas versus Chad Pierre Terrio. You?
Yes, sir.
Present with Mr. Walker, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about September 7th, 2025 in Jefferson County, Texas, you committed the state jail felony of theft. Do you understand what you were charged with here, sir?
Yes.
It says a watch, looks like, of a value of $2,500 or more, but less than $30,000. A state jail felony means if convicted, I got it on the wrong, but this will, we can work it. A state jail felony carries with it no less than 180 days up to 2 years in the state jail. A fine not to exceed $10,000 can also be assessed. Do you understand the punishment range here for this crime?
Yes.
An agreement has been reached between the parties where you would be pleading guilty, not found guilty, placed on deferred or unadjudicated probation, which can be up to 5 years in length. And is there any restitution?
No, sir. She received the merchandise.
And there, again, a fine of $500. Is this your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead in this case? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty?
Yes.
Tell you what's marked as State's Exhibit 1. Did you sign that document? Understand it? Discuss it with your attorney? Or the contents all true and correct?
I did.
State's Exhibit 1 tendered into evidence. Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea freely and voluntarily made. You know what you've been charged with. I must have read to you. You read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement if nothing further. And I'm going to find, sir, you are mentally competent to enter your guilty plea today. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this state jail felony. And when you're found guilty of a felony, it's forever. But I'm not going to do that. I'm going to defer any finding of guilt and postpone this so long as you follow these terms and conditions of probation. And I want to tell you, don't be intimidated. There are 35 terms and conditions of probation here, but most of these are terms and conditions of probation your attorney has to follow. We all have to follow. Commit no offense. Avoid bad habits. Don't associate with the disreputable people, et cetera, et cetera. You can do this. Absolutely. And I can shorten this to 1/3, which is about a year and a half, if you do well. But there'll be a fine of $500. And then there is a course that you are required to take under these circumstances, a theft prevention class. And that's easy enough. And it's a good thing. But anyway, I've signed the documents. Please see the probation officer. You agree, you sign, begin probation. The quicker it begins, the quicker it ends. And you've never been in problems before. Fix this. You're not in the right place here. I know you're far better. Made a mistake. Fix it. Move on. We all make mistakes, and this one is an easy one to fix. Okay. All right. Good luck. Thank you,
Judge.
Yes, sir. Thank you.
Episode number 338 of TCF Live on this Thursday. My name is Dan. It is good to have you here. For those of you who are out there watching, if you have not yet tried it, go up to the pinned chat and click on the link there. That takes you to TCF Court Watch. It is the same YouTube feed and chat that you get right now, but along with it, you get judge bios, you get a list of cases that we're monitoring that will be upcoming, the judges I'm currently monitoring live, a glossary of legal terms, a whole bunch of good stuff. So do check that out, tcfcourtwatch.com. The link is in the chat. Okie dokie, let's go back to Judge O'Donnell, fresh victim there.
Thank you, Judge. Before this morning are two cases, the first of which is 24 CR 245, captioned State of Ohio versus Stephanie E. Doles. And the second is 26 CR 316, also captioned Stephanie E. Doles. Judge, we are here for sentence in both cases. With respect to the earlier case on April 22nd of 2026, the defendant waived her right to a final hearing as a result of a probation violation in response to the motion that was filed in March of 2026, and the matter was deferred for sentence. And in case 26-316, the defendant pled guilty to 2 counts. Count 1 was a charge of possession of cocaine, a felony of the 5th degree, in violation of ORC 292511, and count 2 was an OVI, a misdemeanor of the 1st degree, in violation of ORC 451119, and that matter was also referred to the probation department, and the matter was deferred for sentence until today. The defendant is present today in court with counsel, Mr. Kerr, and we are here for purposes of that sentence.
All right, Mr. Kerr, go ahead.
Yes, briefly, Your Honor. Most of this we already discussed in chambers, or you've received letters that I've submitted, obviously, on Ms. Dole's behalf. I just would point out to the court that I think that she has suffered some pretty significant consequences as a result of her her relapse. As the court knows, she suffered compartment syndrome, which is an extremely serious condition. She's never going to walk right again. This has hampered her employment opportunities. She was previously a server. She recently had a job at Bob Evans and just basically found she just couldn't quite cut it yet. Obviously, so that's a lifelong consequence that she has served, and it'll be a crucial, significant reminder of how important it is that she maintains her sobriety. But I think it's very important to note that she's taken extensive steps to show that she is very serious about her recovery. They've been imperfect, we acknowledge that, but she did complete the 3.5 program, which is basically a full residential program, a 45-day program at New Beginnings. As the court knows, she did have a single episode relapse, and she makes no excuses for that. But I think it's important to note the timeline of how she responded to it. It happened on approximately July 2nd. On July 3rd, everything was closed, as the court will remember, for the July 4th holiday. So she was able to get in for an assessment early the following week. She promptly checked herself back into another residential program, the 3.1, where she is successfully undergoing treatment currently. Since then, she's had a negative drug test. She's on the wait list for housing and sober living, which she will eventually transition to. She's going to plan to be at the Jefferson House. I feel that the move to Ashtabula is a good one for her in a number of ways. It removes her from old contacts that could have given rise to temptation, gives her a new set of surroundings. On the other hand, it does keep her further away from her family she's very close to. But she is interviewing to be a manager at Pizza Hut, as the court knows as well. We mentioned previously, she's doing a medically assisted treatment program as well. She reports that for the first time she has no cravings, and it's also helping her with the pain that she suffers, the nerve pain. We'd ask the court to consider that she has upcoming medical procedures and surgeries. She needs to keep doing her physical therapy. Any sort of additional incarceration will severely jeopardize the progress that she's making both physically and with her recovery. I think Stephanie can do this. I think she's doing everything she can to make sure she does it. I think she's keeping in close contact with her sponsor, who's here today. I think I might like to say a few words on her behalf, if that's okay with the court. Stephanie has a lot of potential. She's a college graduate. She's very smart. She's very gregarious. This has been a struggle for her, but I would point out she did 18 months of probation successfully. She did 3 years she was sober for 3 years previously, from I believe 2020 to 2023, approximately. This is not something that she cannot do. And with the Suboxone combined with a very dedicated treatment program, strong support around her, she can turn the corner. She can move past this. She can live a productive life, and she can realize the potential that she has.
All right, Ms. Dawes, what do you want to tell me before I impose sentence?
Should I stand? Or no?
Sure. Whatever you want to do.
I'll still sit. Everything Justin said was true. I think I should have taken advantage of the mat services before I did. I think I should have realized Walter as a stronger support before I did. I let myself be talked out of a lot of things for various reasons, especially with the MAT program, because I was always worried about withdrawal and I was always worried about being on a substance. Now with my leg and everything that happened, I was on other medications, and so I was already struggling with the withdrawals from that. And I hate to say that everything happens for a reason, but being able to be in a residential facility and going on and being able to look into those options, I think kind of led to something that I might not have otherwise have found. And I wish I would have been able to take advantage of that before the last 4 years and the opportunities that I was given by you and by the courts and by everything else, because of the way that the downhill slide that my life has taken. It's the first time that I felt that I could do it, that I've said to you before that I thought that I told you I've wanted to. I don't know that I've ever said those words that I thought I could. I really do think I can. I think I was lacking that extra push or that extra support, and it would be structure and routine, and it would be one of the biggest regrets, thank you, of my life, if now having discovered that and had these things in place, if I wasn't able to take advantage of that. Sometimes things like routine and structure, you don't realize that you need until they're gone. I wish I would have stayed at 3.5 longer. I wish I would have stayed at New Beginnings longer. I thought I was ready.
Well, let me stop you there.
Yeah.
Let's go back. You started New Beginnings in April, right?
Yeah.
So take me through the New Beginnings program.
So, like the 45 days?
Well, I don't know much about it other than
Sure.
what I've read and what I've talked to Ms. Wehagen about. So tell me what you did when you got there and how it progressed.
So for while you're in what they call the 3.5 phase, you wake up at 6:30, you do chores, and you have groups from 8 a.m. until essentially 4 p.m. every day or 3 p.m. every day. Obviously, there's food breaks and different things in between there, and then you have either meetings or outside the house, which you can get rides to, like AA and 12 steps, or you can do a meeting inside the house. And then after 45 days, roundabout, you can either, if you have stable housing, you can move out of the house, you can go to sober living if they have a bed for you, you can move to 3.1 while you wait for sober living, or I guess those are really the options.
Why do they call it 3.5? What is it?
I don't know, I think it's like a higher level of care than 3.1.
Do you know what that is, Megan?
I believe it's similar to the depression hospitalization
Okay.
program. It's a higher number of treatment hours provided per week compared to low intensity, which is 3.1.
Okay. So you do that for 45 days, then you move to the lower level?
And then you can, if you don't
So what
move
was
home,
that like? What were you doing? What was the routine there?
and 3.1,
Yeah.
then it's you have group in the morning, and then you can get access to your phone and do job search, or you can work while you're on 3.1.
Okay.
People could have their vehicles there if they have like the proper licensure and insurance.
So that was sometime early May, or no, early June?
Yeah. Yes.
All right. So what was the thing with the cocaine?
So that was after I had already left the house.
Left?
As in the 3.1 phase, that was after I had already moved forward from that phase.
Okay. How long were you in that phase?
I want to say it was only 2 weeks. I had housing. If you have housing, they don't keep you on that phase.
Okay. Where was the housing?
In Ashtabula.
Okay. Where did you go?
I went with a woman who I met through Sober Support, who took me to all my meetings, who I had discussed previously with Megan. She worked at Glen Bay.
Okay.
Her name is Jennifer Matthews.
All right. So what was the relapse? What was that? What were the circumstances?
Circumstances were I was alone. I was going through my own belongings that I had unpacked, and I wasn't ready to be in physical contact with the substance. And it was like, I thought I just wasn't ready to be. I've never been in that situation before. I'd never been that soon out of a rehab or that soon and not, I've never been in a room with a drug and not done it, to be quite frank with you. So I didn't know what that would look like. I wish I could say that I knew how I would handle that. I didn't. I made the wrong decision. I panicked.
What did you do about that then?
I panicked and I called New Beginnings.
Okay, and then what?
And then they said, come back in for an assessment. And then they said, come in Monday. And I said, I will. And when I hung up, I called my dad.
Okay, when was that? When did this happen?
The 4th of July weekend.
Okay.
It was before the weekend.
All right, so where are you now?
At New Beginnings.
Apparently they don't do a great job of communicating with our probation department, which is frustrating to Megan and probably even more frustrating to me. So if you're at New Beginnings, you ought to tell them, I need information, okay? And they ought to do a better job of communicating with us, so we know what's going on, okay?
Okay.
So what are you doing on a daily basis now?
The mornings are the same. I have classes in the mornings, and then I had started the job at Bob Evans. It physically was too much for me. I wasn't ready for that, so I'm technically still employed by them, but I'm looking for other employment. And then, as Justin mentioned, I did get the preliminary offer for a management job at Pizza Hut. They just have to go through their supervisor, and I'm supposed to hear back this week.
In Ashtabula?
They've gotten me. Mm-hmm. And then I've been physical therapy. I continue with that 3 times a week, twice a week this week, and then I started the MAT program the week after I got there. I've been there 2 weeks now.
All right. And that's, the MAT is through UH?
Signature.
Okay, so what is it? What's involved with that?
So I had my assessment, and we went over my drug history. We went over the pain management stuff that I had, and the options that hadn't turned out to work for me. And then I went into the office for them to start me off on a low dose. I had originally asked them about the shot. They said that was probably too serious of a leap since I've never been on Suboxone before, also because that's in your system for a month.
What is their...
She said it's supposed to help with cravings, okay. And
cravings for what? Opiates?
For opiates and cocaine.
Okay. So do you take that every day?
Yes.
And do they give you enough dosage for a certain period of time, or?
So now they're doing it per week. They'll give me it for the week, and then the house gives it to me. It's twice a day, but half and half, and then they do it during their med times when they have clinical staff there.
All right. So how often do you go to Signature Health?
Now I'm going weekly, and then they'll go to bi-weekly after I'm on it for. I think I have appointments set up for 2 months.
Is the only reason you go to get the medication?
I got blood work done. I do a urine screen and then get the refill on the prescription, and then I speak with the doctor or the nurse.
All right. So
to check in, just see how it's going.
With your rehab for your leg,
yes.
What's that schedule like? You said 3 times a week right now?
This week I have it twice. I had it yesterday. I have it tomorrow. And then I had scans at UH last week downtown for, it was an EMG and an ultrasound for the nerve. The procedure is going to be nerve related. That's for the pain.
All right. When is the procedure?
They're supposed to schedule it next Friday.
And did they, when this happened, they gave you were on prescription medication when the injury happened?
No.
After you were injured?
I was on I was being prescribed it when I got out of the hospital.
Yeah,
Yes.
that's what I mean.
Yes.
What were you
I would-
prescribed?
Oxycodone.
Did you take it?
Yes.
All right. What are they telling you about the prospects for this surgery?
That it should be outpatient. He said, even if my scans hadn't looked the way that they did, which were good, that he could do it. He said it's supposed to, the way they described it is open up the neural pathways that are not communicating with my upper leg to my lower, because the surgery was in my upper leg, and I'm having pain in my lower leg. So he said it's supposed to open up the neural pathways and alleviate, that's the word I'm looking for, alleviate the pain in the lower leg.
Okay. How often are you going to meetings right now?
Now I'm going to more like 4 a week.
And who's your sponsor?
For Walter Nelson is temporarily sponsoring me until I can find a more active or female sponsor in Ashtabula. He lives in Madison, so we're not able to meet as regularly as most people do. And also the house does not allow male sponsorship rides for men, so that's why I'm.
Did you want to say something? Yeah, go ahead.
Your Honor, I met Stephanie 2 years ago. She approached me at a meeting, and I guess she had been watching the way I live and said that she was very sad at meetings and bored at meetings and didn't like them, and that she found me very happy at them. And she thought that was very attractive. And I started talking with her. We spent probably, at that time, 4 months together every day, talking about sobriety, going to meetings every single day, and she stayed sober through that. There came a time where she had an issue, and sobriety is not a straight path sometimes. I truly believe that the big book of Alcoholics Anonymous says that God needs to beat us into reasonableness, and I believe that's true for drugs. You've probably experienced that in your life. And so, because of that, this last relapse that just happened here with Stephanie, I've heard something a little different from her. And sometimes I think we need to skin our knees because we don't think that we really have it as bad as we do. And I think that Stephanie started to quit fighting. And that's a key thing for me. In my 41 years of sobriety, I've seen and worked with thousands of people. I really believe, Your Honor, that confinement in prison or jail probably is not the best course for Stephanie. I don't believe she's violent. She's one of the kindest, sweetest, gentlest women I know. She helps others, she takes girls to meetings, and she wants to be part of sobriety. I think at this point, with the 41 years at stake of my sobriety, my work, I believe that Stephanie's on the right course. I wouldn't say that if I didn't believe it, Your Honor. Thank you.
All right, thank you. When you go to the meetings, are they AA or NA?
AA.
All right, anything else you want to tell me? All right, Ms. Naroda?
Judge, as the state discussed in chambers with defense counsel and the court, the state sees it a bit differently, and the state at this time feels the appropriate recommendation is a prison sentence.
So this entire case that you're here for now, you were semi-conscious, I guess, as well, from my read of the report, in your car on Plaza Boulevard, in which they gave you the OVI and then the possession of cocaine. What were you doing that night? Where were you coming from? Where were you going? It was 2:26 in the morning.
I was going home from my girlfriend's. I don't know why it was so late. I do remember that I was having issues with my contact lenses. They had been bothering me the whole way home. And I obviously stopped in a very inappropriate place to.
What had you taken that evening?
Substance-wise?
Yeah.
I know I took my gabapentin. I do believe that I had left my gabapentin at home. My girlfriend has cerebral palsy. She also is on gabapentin. I know there was some discrepancy over my medication, so I think that's why that hour of the night was what it was. I don't remember what substances I took that exact night. Obviously, substances were involved.
What was the story with the cocaine?
That evening, that there was cocaine found in my car.
Uh-huh.
What's the story?
Yeah.
Meaning like that there was. Yeah, I was in possession. Oh, that I was in possession of cocaine.
Where'd you get it from?
I don't remember.
Where did you normally get it from?
I had a contact out in Cleveland Heights.
Okay, who was that?
I did not know their name.
And how did you know how to find them?
They're in my cell phone.
How did you contact them in the first place?
I would have to think about that. I would have to think about who exactly I got it from.
How long have you and I been seeing each other?
Years.
8 years, roughly 7, 8 years? Okay. From being here, do you know enough not to try to bullshit me? Because when I ask questions, I ask questions for a reason.
Yes,
and the reason is I want to know the answer because you're in a little interview here is what you're in. Okay, so I want to know what I'm dealing with, and so when I ask you where you got it, the answer I'm looking for is where you got it. How you came into contact.
I got it from my dealer.
Okay. And you just didn't, unless you just wandered down Euclid Heights Boulevard one day and found a dealer on the street corner.
That's fair.
You found a way to get in contact with the dealer. How was that?
That's very true. From the phone number that I have in my cell phone for this person, I would call them.
And you got that phone number?
Yes, they're in my phone. Their person's name is in my phone.
Right.
His nickname is ICE.
Okay.
I don't have this person's real. Real.
And you got that.
Name.
You got that name and contact number from somebody, right?
At some point, yes.
From who?
I don't know their last name.
Okay.
What's their first name?
The best identification.
The person's name is Tony. I don't know any other information.
Do you still have your phone?
I still have my cell phone. Yes.
Do you still have the contact in your phone?
Probably. I don't know.
Why?
I don't know.
Okay. Well, is there a reason you want to keep ICE in your phone?
I don't have that person's phone. I don't know. I don't know. I'm very. Can I take a breath?
Yeah.
I just hear I'm just confused.
Would it be fair to say that you haven't deleted these, but that doesn't mean that you're actively contacting them? I mean, in the sense that I have people on my phone I have like 10,000 contacts on my phone.
Yes, I still have the same phone number that I had in February.
But you haven't affirmatively deleted them, but perhaps you should. Is that what
I'll get a whole new phone number. I don't.
Okay.
Listen.
My dad has suggested that to me in the past. Yes, I'm getting confused about. I stumbled.
See, the concern is when things aren't going as well and something happens that throws you for a loop, that you're going to go to your phone and look under I and head up to Cleveland Heights. Okay, that stuff should have been deleted from your contacts a long time ago.
Sir, I understand. I can appreciate that, absolutely.
So How many contacts do you have in your phone?
Hundreds.
Okay. So it'll take you a half hour to go through your phone, your contacts, and get rid of the schmucks in your contacts. There's no excuse not to do that immediately. Okay?
Yes.
Because the mindset that that's still in your phone, in your contacts, whether you go to it or not, concerns me.
Okay.
Because we've been going round and round for 8 years now. Sometimes good, sometimes bad, right? Right? All right, I've reviewed the pre-sentence report. And I have listened to what you said. I've reviewed the letters that I received on your behalf that Mr. Kerr had provided to listen to your sponsor. And to counsel, I've considered all the provisions in 29-29-11, 29-29-12, and 29-29-13. I'm going to place you on community control on the new case for 4 years, on the felony. On the misdemeanor, I'm going to sentence you to 180 days in jail with credit, or with 175 suspended. You are to do 5 days by September 30th, or you're to report September 30th at 9 a.m. for 5 days, or you can substitute the driver intervention 3-day program and complete that prior to that period of time. Then those days will be vacated. And I'm going to suspend your license for a year, effective February 27 of 26, and you're going to pay the costs on that case. Are there any other mandatories I have to do on that, Lisa?
No.
I don't think that there are. But
Fine, the fine.
oh, what is it? Is
It's up to-
it's $575?
I believe it's $575 now.
And a mandatory fine of $575.
Judge, the 5 days had to be done by September what?
30.
Or the driver intervention?
Or if she does the driver intervention program, then those days are vacated. So that's with regard to the OVI.
Your Honor, is it possible that the court meant to sentence Ms. Doles to a 3-day sentence, because that's how long the 3-day DIP program is?
No, I'm going to give her incentive to
to
do the 3-day instead of 5 days in jail.
Okay. Right. That makes sense.
All right. On the 4 years on the community control on the new case, 1 day in jail with credit for 1. You're to have no illicit drugs or alcohol, and you'll be screened. You're to complete the New Beginnings program and follow all their recommendations. You're going to continue the MAT program with Signature Health and follow their recommendations. You're to attend at least 4 AA meetings a week and maintain a sponsor. You're going to get a valid driver's license after your suspension is up. You're going to maintain full employment when you have that capability. You're to go to only your current doctors that you go to right now. How many do you go to? The UH and Signature? All right, so you're restricted to those folks right now. If you need a additional doctor or doctors, then you're to inform probation who they are. You go to only one dentist and one pharmacy for your prescription medication. Take your medication as prescribed. And, sign releases so probation can get your records. And please inform New Beginnings that when we request the information, we need the information. You understand that? Yes? All right, any other terms, Ms. Wehagen?
No, Your Honor.
All right, do you understand all the terms? All right, if you don't comply, the state will file a motion to terminate your community control. If I find you violated, you face 12 months in prison on the 26th case. On the 24th case, I'm going to extend your community control to July 22nd of 29. There's also a potential 12 months on that case if you don't comply. Do you understand that?
Yes.
All right, anything else, Ms. Naroda?
The extension date, I'm sorry, Judge.
7/22 of 29.
Thank you, Judge.
Mr. Kerr, anything further?
Nothing further. Thank you, Your Honor.
All right, Stephanie, this is completely in your court at this point. Good luck to you.
Thank you.
Alrighty, friends, hour 3 of TCF Live. Let's go back to Judge McNally. Check back in there.
The pre-sentence report, correct?
Yes, I have.
And before we go on, I still need to tell you again, you have the right to a lawyer. I know we covered this, but now you've read the report. If you would like an attorney to represent you, well, I will appoint you one at public expense.
No, Your Honor.
You waive your right to a lawyer?
Yes, I do.
Anything you would like to say? And by the way, I do need to add, is anybody here from Lowe's Loss Prevention, either in court or on Zoom? Anybody here?
Not on Zoom, Judge.
All right, so, she allowed you to plead to attempt retail fraud.
Yes.
You can't read this. It says, older case, defendant since changed his something. Seeing no objection, suspended sentence, fines, costs. Has something jail sentences. Can you tell me what he was?
Yes, Your Honor. When I served 2 years and I signed multiple writs to the court, and every time they were denied.
From me?
My mother.
From me?
Yeah. Well, I sent them to the 33rd District Court.
Well, let me see here.
That was probably what the prosecutor was trying to put out there.
I don't see where I got any. I mean, I don't. Did I send you a letter back saying I'm?
No, my mother called up here multiple times from me bouncing from county to county jail, and the same response was just have him turn himself in when he gets released.
Well, I don't think I ever got a plea by mail. I always respond to those. I don't mind telling you. And I don't see any plea by mail receipt in the file here. I'm not saying you didn't send it. Well, I am.
You know, because I was dealing with this with other cities right now too. The only one that ever responded was something. So
I just don't think you sent us one for whatever that's worth. I'm not trying to quarrel with you. I just.
Oh, yeah. I'm trying to.
When's the last time when were you in custody?
I was released in July 2025. I've been out for.
And then you went and got another one, right?
No, I haven't been in parent trouble since 2025.
I know you were released in July of 25. Is that what you told me?
Yes, I haven't been incarcerated from 2023, August of 2023 to July of 2025.
Picked up another one out of camp.
No, that was just me taking care of one. And also I'm taking care of on the Southgate right here.
Jeez.
Yeah. Your Honor, I've came a long way in the last year. You know, I got a job working for DTE. I'm actually about to be off probation this week. I finally got my hours worked. I'm, you know, I've been sober for 35 months.
How old are you?
36.
Better.
Oh, trust me, Your Honor, I get that every day from my mother.
Where's your mother?
Right there.
So I see what happened now. I mean, this was just so bad, but all these offenses preceded the 2 years you spent, correct? Is that what you're telling us?
Yes.
And that's the way it looks on here.
Yes.
What do you do with DTE?
I'm a maintenance mechanic. I also brought the pay stub just for verification. Worked real hard to get there. So.
I mean, I came out here thinking they should have never given you attempted retail fraud. They should have charged you with a felony. I don't understand this. I'm not sure I understand why they do this, but I'm not going to quarrel with it. That's their call. It's not mine. You should have been charged with felonies here. You should have been going to jail for years on something like this.
This service, Your Honor.
I know, you deserve to serve the years. You gotta really push judges in the Wayne County Circuit Court or any court to give you 2 years on a retail fraud unless your record's just somewhere between horrific and abysmal.
Right.
300 fines, 100 costs, 75 victims' rights, $50 justice assessment, 5 days court work program, $175 charge for that, $700 or 45 days. You have to serve 5 days on the court work program. I can't believe I'm not sending you to jail, but I guess when I look at these, everything did precede this before you spent the 2 years. Had you sent me a plea by mail and said, hey, I just got sentenced to 2 years, I would have granted that, but I didn't get it. So that's what I'm gonna do. Can you pay all this today?
What's the
700.
Altogether?
Correct.
What about my $300 bond?
You know, the bond will apply, so you would have,
$400?
correct.
Yeah, I can pay that today.
All right, and then you'll meet with probation to set the court work program.
Oh, do they do it on weekends?
They do it on Wednesdays and Saturdays,
Okay, perfect.
but Wednesdays infrequent. Good luck.
Thank you.
You'll meet with probation.
All right.
Judge, I received that appearance now for K4M towing.
And sorry to interrupt, but could you put me in a breakout room with Williams Bay?
I thought I did. I'm sorry, Miss Patillo.
Okay, thanks.
Who's the call that stuff?
Okay.
Alrighty, friends. Well, they look for their next contestant. Let's go to Louisiana, check in with the board this morning.
Board be called to order. Today's time is 8:47. My name is Pete Freeman. I'll be the chair today. To my right is Ms. Stapleton. To my left is Mr. Tillis. With staff at headquarters, please introduce yourself.
Jasmine Thompson.
Okay. Is there any staff with you over there, Mr. Kuzan?
Deputy Charles Whitley, JPSO.
Okay, Mr. Whitney, thank you for having us today. Has he been giving y'all any trouble? Do you know?
No, sir.
Okay, thank you. Appreciate it. All right, Mr. Kuzan, please state your name and DOC number for the record.
Good morning, sir. Antonio Kuzan, 741197.
Okay. And you're here today for your revocation hearing. Do you have your parole questionnaire with you?
Yes, sir, right here.
Okay. Do you realize you're not eligible for appointed counsel? If you wanted a lawyer, you would have had to hire one.
Yes, sir.
Okay. You ready to proceed today?
I'm not prepared because my two witnesses that I have, my father and my wife, they not present at this time.
Where are they? Do you know?
Well, my wife, she's not answering the phone right now. Her phone going straight to voicemail.
Hello?
Oh, well, there go my father.
Okay, good. Okay, well, we're gonna go on. If we got your dad, we're gonna.
But I still need her because she have proof of my check stubs for my job.
Girlfriend's on. Okay, girlfriend's on too. Okay,
She
we got
on?
both
Okay.
on now. Yes, sir. Okay, so we're gonna proceed. And as you stated, speaking on your behalf today will be Mr. Antonio Nathan, your father, and Chloe Carter, your girlfriend.
Okay.
So, we'll get to them at the proper time. Your case has been assigned to Mr. Tillis. He will be leading and questioning.
Good morning, Mr. Kuzan.
Good morning.
I'm going to read some violations and you can answer guilty, not guilty, or with a statement. Violation number 2, you failed to report to the parole agent as directed. How do you plead? Guilty, not guilty, or with a statement?
I plead not guilty with a statement.
Okay, tell us about it.
Yes, I did. Got a chance to talk to him or whatever, but like during the time I was working, I was doing things. I was never getting calls. No one never come to my father's house or anything like that. And then when I advised him of that, he was like, I was supposed to call him. So.
Why didn't you call him?
Because I was busy working, things like that.
All right, violation number 3, you failed to notify your agent when you moved from your last known resident, therefore not allowing your agent to make home visits. How do you plead? Guilty, not guilty, or with a statement?
Not guilty with a statement. And my father, he could give that speech for that one because I never changed my address.
Okay, Mr. Kuzan, you want to talk and tell us what happened?
Mr.
Nathan, I'm sorry, Mr. Nathan.
We're going to get your statement too, Mr. Nathan, while we at it.
Mr. Nathan, can you hear us?
Yes, I don't know why I keep muting. Can you hear me?
Yes, sir. Go on and speak to him living with that at that address, and also tell us what you want us to know about your son.
Well, from my understanding, I never met, I never gotten a phone call because I know in the past, I can't remember if it was my son when he was a juvenile or whatever, he had probation, and they probation officer came out. I went to the one on the location that was on Poland at the time. I don't know if they still there. Met probation officer that came out. So I'm aware of how they supposed to reach out. So I never got a phone call. No officer never came out to my address until I found out. All of a sudden, this officer, probation officer, started calling me when I started learning about what my son's supposed to be charged for. Meaning that the reason why he was calling me because I was assuming that he had an attachment out on him. That's when I found out who the probation officer was. So I told the probation officer that my son is be at his girlfriend house. I could give you the number to where he sleep at. That's still the nature. And yes, my son was working. He did have a job.
Other than that, he was staying out of trouble, wasn't getting into anything, and I just found that very strange because I used to ask him, "Where's the probation officer? Why he haven't? Why you talked to him or did he reached out to you?" Because I see no one ever called, no probation officer never came here to the address. So,
Okay.
but yeah, that was it. But I didn't hear anything from this officer till found out after my son was arrested the reason why the probation officer started calling my phone because then it started adding up to me. I was hearing the word on the streets from his female friends that there was an attachment. So,
Okay.
yeah.
All right, thank you.
Mhm.
All right, Jules, you want to go? Okay, let's get at, Miss Chloe Carter. Miss Carter, the girlfriend, let's hear what you have to say. Miss Carter?
Ms. Carter, can you hear us? Okay, well, let's go back to the question.
Okay.
I know something was wrong with her phone when I was calling. I don't know if it's set up and she's not on there. I'm not sure.
Yeah, we can hear her, but she's not talking. Okay.
Okay, I'm gonna go with violation number 4. The parolee engaged in criminal activities when the parolee had 2 activities active warrants out of Jefferson Parish simple burglary and wearing a mask hood in public with items number H19 and attempted burglary. And you have an active warrant in Kenner, Louisiana for ILL carrying of weapon, a felon carrying a weapon, stolen firearm. How do you plead? Guilty, not guilty? Or with the
Not
state?
guilty.
I'm sorry, there was a little bit more too. Officer from the motor vehicle traffic control signal violations was a possession of drug paraphernalia, possession of Schedule 3 marijuana, evident by arrest in the New Orleans Police Department. Subject also had probable warrants out in New Orleans. All charges are still pending in the 24th court. Pretrial conference is for May 18, 2026. Continuance 8/6/26. How do you say you plead not guilty?
Yes, sir.
All of those charges?
Half of them is dropped. I only got 3 that I'm still fighting.
3 of they?
The attempt burglary, the burglary, and I'm on the illegal camera. And matter of fact, 4 and an aggravated flight.
And the carrying of a weapon was dropped?
No, not yet. Still fighting.
So did you have a weapon?
No, sir.
You didn't have one?
I didn't get caught with one, around one. I was placed on the scene.
Were you driving the car?
No, sir.
Whose car was it?
Another female friend that I was dealing with, when they advised her of the incident, she told them I was in the car. But in my statement on my paperwork, she recanted her statement. At first, she gave them another name. Then it said after they advised her of the consequence, she gave them my name.
Okay, violation number 5. You engaged in criminal activity when you committed the offense of carrying. That's the same as almost number 4. How do you plead on that? Guilty, not guilty with the statement?
Not guilty.
Okay. Violation number 9. You failed to notify your agent when you moved from 4764 Sherwood Drive, New Orleans, Louisiana. Your last known resident, therefore, not allowing your agent to make home visits. How do you plead on that?
Plead not guilty because I never move. Not guilty with a statement, sorry.
Okay, go ahead.
Because I never move. I just sometimes sleep by a female friend.
How often do you stay there?
Out the week, probably I see about 3 times. Because there done been times I done went to work from there. So I admit at least 3 times out the week.
Have you ever been on supervision before?
Supervision, yes, sir.
Okay, so you don't understand that you got to contact your parole officer, you got to tell him where you're at?
Yeah, I understand. I do.
All right, number 10, rule number 10, you failed to pay supervisional fees in the amount set by the Louisiana Department of Correction. Status since 5/1/2025, which caused you to be in arraignment of $693. How do you plead?
I plead guilty because I wasn't paying.
Okay. Is our girlfriend, his girlfriend, she on there?
All right, let's try. I can see if we can get her. All right. Ms. Carter? Carter, can you hear me?
Okay. All right. Well, what was your girlfriend gonna?
What you had said she was gonna tell us? What she was approved? Your girlfriend. What she had proof of? That you were working?
Yeah, that I was working. She had proof of my check stubs. She had proof that I wasn't always at her residence and things like that. And
I believe that.
Yeah, and basically, that I wasn't, interfering in any criminal activity.
Gotcha.
Because the situation, what I'm incarcerated for, that's from another female.
Gotcha. Okay.
You got any? I don't have any more questions, Ms. Carroll.
You have any questions, Ms. Carroll? Okay. Panel ready to vote?
I'm ready to vote.
Okay, Mr. Tillis is ready to vote. Go ahead, Mr.
My
Tillis.
vote is going to be to deny violations number 2 and 3.
Mr. Tillis. Mr. Stapleton.
I'm gonna vote to revoke you because you weren't at the address listed, so, number 2, number 3, and number 4, because they found probable cause in the arrest report for the gun being found. And number 5, let's see. And you admitted, and your father did, because he gave me the girlfriend's address and phone number, that you were not at the address that you stated, so that's number 9.
All right. And I find you in violation of condition number 2, 3, 4, 9, and 10. Today your parole has been revoked. Good luck to you.
Okie dokie, friends. Final half hour of TCF Live. Let's go back to Judge Stevens, new contestant there.
24 CR 1782 is now called the State of Texas versus Michael Stelly. You are charged with a state jail felony of theft because it is alleged you have 2 prior theft convictions out of Hardin County and Jasper County. Then if you steal a pack of gum, it's automatically a felony from here on the rest of your life. So you're looking at up to 2 years in state jail. What are we doing on that?
We've gone over discovery. I mean, it's more have talked quite a bit about this case, and we're ready to put this on the trial docket. It's like you said, it's basically a small level shoplifting that's increased to a felony because of priors.
Well, was there an offer?
Yes, sir.
Yeah.
Which was what?
18 months, right?
Flat time?
Yes, 18 months state jail.
All right. Okay, well, we'll set it for trial. That's all we can do with this. All right.
Yeah. That would actually be different. So maybe.
Vernon Williams.
Nothing.
Ma'am? That's it. I'll email your attorney.
Yeah, okay, that's what I talked to you saying.
Okay, 25 CR 1839 Vernon Bronson Williams III, no answer. I asked the bailiff to call into the halls for Vernon Bronson Williams. Yo. Okay, we're back to Vernon Williams.
No response.
No response to that name called here in the courtroom. No response to the name called into the hall. Defendant has failed to appear. Warrant shall be issued for his arrest. His bond was,
$100,000.
whoa,
Make it be another bill.
whoa. All right, his bond is revoked. It's going to cost a lot of money there. And it is doubled to $200,000, plus the defendant must have a GPS device. Did he have a GPS device ordered before?
He did.
Yeah. Oh, that kind of, and he would have to have a GPS device, and home confinement. And a warrant is issued, and that is the way that shall be done. I've got Darren Patterson on Tom Burbank, but I hadn't even seen Tom. Is there any Darren Patterson? Have you seen your attorney? This was a drug patch issue. Let me look at what this issue is. Darren Patterson. You know, I've got a Jordan Edmondson.
Yes, so that was an add-on.
No.
He's set for trial on Monday, and I think this was kind of the last minute.
Yes, he'd been waffling on the offer, Judge, so we just wanted to make an official
Where is
acceptance
he?
or withdrawal.
He's in Texas.
And I want to withdraw the offer.
Huh?
I want, if he doesn't accept the offer today, I just want to withdraw
What
it
you
and
gonna
then we're,
Okay, well then we'll set it for trial, no deal. Okay, just tell him. I don't think he needs to come out here.
Okay.
So that's, when is it set for trial?
Monday.
All right, be ready, because we want to pick a jury maybe, probably. That's, and then.
That's what you know, you know what you're doing. Yes, I'm going to say that.
Well, I see on this Patterson matter, we've been having, I'm surprised, Tom isn't here. Where's Tom Burbank? He's normally here. Well, I got a warrant for his arrest. His bond is with her. His bond is going to, he's always busy. Okay, so,
Maybe stuck in another court. I'm not sure, Judge.
so on Patterson, who failed to appear, I made my findings.
No, Mr. Patterson is here.
Where's Darren? Right there. Okay.
William.
Well, yeah, it was.
Yeah. Judge,
Birmingham drug court.
Okay.
Alrighty, friends. Looks like it might be a bit before they get another contestant. Let's go back to Judge McNally.
All right. How you doing, Mr. Thornton? Your name? Tell me what you're going to do here.
Probation, if I'm not mistaken, and I.
Hang on a second. Wait a minute. Wait 1 second. We show cause you for July the 8th.
Yeah, I got an email from my probation officer that you wouldn't be here, and it was moved.
Okay. So I have here a case. I don't think he has a show cause in front of me, does he, Heather? His show cause is in front of Judge Hessen. I don't mind arraigning on that. But I don't think he has one in front of me unless I'm wrong.
Let me take a look here at the case that I'm showing, unless they dismissed it and didn't tell me, but on case ending in 260, I'm showing a show cause along with a prosecutor review.
I see. So it's more of a prosecutorial review. Let me see something here. Who's your probation officer?
Miss O'Donnell.
I'm gonna ask you to call him, then I'll get her. Hey, can you come in here on Mr. Thornton, please? Thank you, thank you. So you have a show cause in front of Judge Hessen, and you have a review hearing in front of me, and it looks like the charge in front of Judge Hessen is that you failed to pay your fines and costs ordered, balance owing 270, and you failed to clear all your warrants in the case in front of her by January 31 of 26. So those are the charges in front of her. If you plead guilty, if you're found guilty, it appears as though you have 2 prior technical violations. She could revoke your status and give you 90 days. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes.
You have a right to a lawyer. I'll be happy to provide you with one at public expense. Do you understand that?
Yes.
Would you like a lawyer?
Yes.
I'm going to enter a not guilty plea for you on her case. I'm going to give you a lawyer. We're going to give you a lawyer on that file. Ms. O'Donnell, your name?
That's what I'm.
I'm a little concerned. I'm not sure what I did here. It doesn't look like there were any notes with regard to his review hearing on the resist and obstruct. Has he paid everything on this, Heather? Okay, on my case?
On the one ending in 260, he has a balance of 270.
They still have a warrant that's still pending as well.
Well, I can't go on this. You got 771.1 status. You blew that. I can't extend it beyond a year. I put you on probation July 23. You didn't comply with probation. I told you a long time ago, son, I said, if you don't have the money, come talk to the court. It really isn't that hard. There's just that amount of time it takes and lesser amount of respect levels. And you don't do that, now you're going to have this conviction on your record.
But I keep in touch with her.
She's not the judge.
And
Don't interrupt. She's not the judge. I'm giving you a lawyer on both of these. I want you to write the notes on the back here, on my case, and then we're gonna set you up with a defense lawyer. Who would we set him up with? Who's got a probation today? Is it Mr. Shemke or I don't know?
Well, Crawford's our house counsel and Patillo is overflow.
Okay, I'm gonna let you guys figure it out, but I arrange you, I'm entering a not guilty plea, you have to go in front of Judge Hessen. Your lawyer's gonna represent you on both of those, your lawyer's going to go over this. You should have just come and talked to me, I don't know why you didn't. You know, you got yourself in a real pickle now. I can't extend 771 status past 1 year and we're at 360 days. That's the problem. All right, set him up with a lawyer and we'll go from there. Thanks. People against Cortez Nakari Gordon, 26W8435666A and B and C. Where is Mr. You got him, right, Mr. Slavin? Good morning. Your appearance?
Good morning to your honor and to your staff. May it please the court, Joseph Slavin, P number 61705 on behalf of Mr. Gordon, who is here with me. Your honor, today's date and time set for an arraignment, and we would like to waive formal reading and stand mute.
Sir, your name, please?
Cortez Gordon.
Okay, so you're standing in for his lawyer of record. It says Thea Barrick, is that right?
That's correct.
And any objection to that, Mr. Gordon?
I'm sorry.
Do you have any objection, Mr. Slavin, standing in for your attorney of record?
No.
Okay, Mr. Slavin, is this a first offense?
Yes, your honor.
He's allegedly got a .127. I'm gonna enter an not guilty plea, indicate he stands mute. I'll give him $1,000 personal bond. Sir, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, marijuana, or illegal controlled substances. Do you understand that, sir?
Your honor, before he answers that question, Mr. Gordon is a resident of the state of Ohio.
Okay.
He drove up here to be here with me in the office so we could Zoom together and also discuss the case together. With regard to that, he has every intention of being at every
Yeah, I'll be glad to let him go to the state of Ohio. No problem. I need his new address, though, Mr. Slavin.
Mr. Gordon?
23720 Lime City Road.
I'm sorry, you gotta repeat that. What city road?
Lime, Lime.
Lime City Road, okay.
Perrysburg is the city.
Yep.
Ohio. Postal code 43551.
Okay, good enough. So we'll give you a court date. I'm entering a not guilty plea on the open intox as well, as I think I indicated. Plea of denial on the speeding. And why don't we give them a new court date, Heather?
We can do August 5th at 9:15.
Is that good with you, Mr. Slavin?
Let me check. August 5th, 9:15. Yep, that works for pretrial.
Okay, August 5th at 9:15 will be the court date. Anything else, Mr. Slavin?
No, the only thing, Your Honor, is I guess Mr. Urick made us aware of the new, we're not doing discovery order, we're doing the email to Ms. Parks. With that email and then that coming back, in order for us to see whatever discovery that they're going to have, that might make a little bit of a tight window. Perhaps there might be another date that's at least
I mean,
a week.
I don't know why he's saying they're not going to do discovery orders. I'm going to sign those.
I mean, all I know is that the new procedure for getting discovery is send the email to iParks.
I don't have any problem with giving you a later date. Let's give them a later date, Heather.
All right, we can do 4 weeks. That's August 19th. We could do 9:15.
August 19th works well.
All right, that's what we'll do. August 19th at 9:15. Okay.
All right. And Your Honor, will that pretrial be by Zoom or will you prefer us in person?
I don't mind you being in by Zoom as long as you're both in the same place. I'd really prefer that. So you can either both be here or both be in your office or.
Very good.
Okay.
Thank you, Your Honor. Yep.
Have a good day. Thanks.
You do the same. Thank you.
Koreshi.
Okie dokie, friends. We're going to have a few minutes of TCF overtime that I wasn't planning on, but I don't know if you noticed that attorney that was Joseph Slavin, and Julie Sassy just asked in the chat, I wonder if Judge Slavin is related to this Joseph Slavin. They are one and the same. That is Judge Slavin, who is no longer a judge. And I found this out because when I saw him, I went searching. I'm like, did he get voted out? Did he retire? What's going on? Well, here's what's going on. So we're gonna cover this. This is as of May 29th, 2026. This is an order from the Michigan Supreme Court in Lansing. That is a formal complaint, and it says Judge Slavin be conditionally suspended without pay for 6 years, effective on the date of this decision. So he is not a judge anymore. There are misconduct allegations here. Count 1 in the fall of 2021 and early 2022. Let me hold on here. Let me scroll it on the screen as well. I've got it going on 2 screens, one where I can actually read. Actually, if I just enlarge this, I can probably read it here. There we go. Where is it? Right there. Fall of 21, early 2022, respondent knowingly made false statements to the chief judge, who I believe was Shackelford over there. Respondent knowingly made false statements to the chief judge of his court regarding whether respondent had recorded a conversation with the chief judge on November 5th, 2021. Count 2, use of judicial position to help a candidate on several occasions in 22, 23, and 24. Respondent used the courtroom and facilities assigned to him to promote the candidacy of a lawyer who was running for election against the chief judge. Count 3, inappropriate demeanor and disrespect. Respondent made disrespectful public comments about the chief judge and employees of his court on several occasions from 22 to 25, in violation of Canon 2B, which requires a judge to treat people with courtesy and respect. And they give examples there. Yeah, it was Judge Shackelford. Called her Judge Shackle Fool. Stating to a litigant who appeared in his Zoom hearing by mistake, who he asked the time of a Zoom meeting hearing in front of Judge Shackelford, God damn it, before giving the litigant the correct information. Referring to his chief judge, stating, we're going to have a bonfire and taking everything with her name on it, and she's effing voted out, gone. I will bring burn barrels. Part D, stating to his court officer after the court hearing while still streaming on Zoom in reference to his chief judge, voters should all know that this is Judge Slavin, that you got to have people who carry the load. You wouldn't hire a milkman who couldn't deliver milk. You wouldn't hire a doctor who doesn't know how to doctor, just saying. Part E, commenting on a court employee referring to her in a derogatory manner, saying, she can walk her fat ass right up here. I don't know who the F she thinks she is. I'm sick of this shit. I'm a goddamn judge and she's nobody. 'Cause one of her effing little bees need to get a break or take a piss F off. Here's an idea, go F off. And it goes on and on and on. So, count 4, disrespectful emails. Lots of good data there. Count 5, failure to wear a robe. I've seen that on the streams before. Count 6, concealing his face on Zoom hearings. Count 7, undignified behavior. Count 8, interference with court staff. Count 9, knowing violation of law. Count 10, false statements to the Judicial Tenure Commission. So, yeah, like I said, I wasn't necessarily planning on getting into any of that, but I saw him there, and I didn't realize all of this went down. So anyways, there you go. just thought I would have a couple of minutes overtime to share that with you. That I wondered, because I haven't seen his streams in a while. That would explain why. Alrighty, friends, that does it for today. We'll be back tomorrow, 9 a.m. Eastern, 6 a.m. Pacific. I hope you enjoyed. We had some good hearings today, so it was good. Wisdom I leave you with today: the man who moves a mountain begins by carrying away small stones. Some unknown guy named Confucius said that, so enjoy. I hope you had fun again. I look forward to seeing you tomorrow. Thank you all so much, and go have a good day. Take care. God bless.